mere service, but a catalyst for wider socio-economic development of the country. Some of the features which I would like to briefly touch upon on the new act which has received assent recently is to first to replace the outdated and outmoded three acts which are about 150 years old. The new act enhances and empowers the consumers by fostering an environment that benefits both service providers and consumers. It prohibits anti-competitive behavior, promotes transparency, and the legislation aims to empower consumers so that they can be aware of their rights and remain protected online. The other important feature is to promote infrastructure development and roll out new technologies like 5G and 6G. This includes measures to streamline and simplify regulatory processes, allocate spectrum, and incentivize private sector investment. Another pillar which is important in this act is and ensuring privacy and data security. The act emphasizes that privacy and telecommunications data will be by design. Frameworks for data protection and cybersecurity have been made integral to the functioning of telecommunication networks. The Act also ensures that and emerging technologies are recognized as a powerhouse for the next decade, which our country is currently at. It ensures that we are perhaps first or few countries which have provided for regulatory sandboxes, collaboration between industry stakeholders and research institutions. The next new or essential feature which has been there as a constant in the past decade, but now has been exemplified in the Act, is ensuring universal access by use of which will ensure that digital divide is bridged. All unconnected people are connected through reliable, affordable telecommunication services. I hope that officers who are here not only understand the provisions of the Act, have the opportunity to interact with each other and come up with guidelines, thoughts, ideas, which will help us in duty while formulating the rules under the Act, which are under process at this point. I compliment again DG NTIPRIT and also a large number of officers who have joined this webinar. I am told about 480. So people have subscribed to this. Wish you all the best and hope that we'll be able to interact more frequently on this and receive suggestions from all of you. Thank you so much for this opportunity and wish you all the best.
Thank you, Honorable Secretary, sir. We at NTIPRIT would like to express our sincere gratitude to you, sir, for sparing your time during your official visit to outside Delhi. I'm very sorry that the connectivity was a problem, and that's why you could not connect through a video call. But thank you very much, sir, for addressing, and your words are real motivation for us. We have organized this webinar on your behest, sir, on your instruction, and I'm very sure this is going to be a very useful webinar for sharing the information and knowledge about the salient features of this revolutionary Telecommunication Act. Thank you very much, sir, and seek your permission to proceed for the next sessions of the webinar. Thank you, sir. DG sir, can we
Yeah,
proceed with the can I proceed with the welcome address?
yeah, please continue.
Okay. So, Honorable Secretary Telecom, Dr. Neeraj Mittal, sir, is most likely is present right now also. Respected Member Finance, Member Services, Member Technology, sir. Respected Director General of NTIPRIT, Shri Devkumar Chakravarti, sir. Esteemed speakers, distinguished guests, and participants from different units of DOT and its PSUs, BSNL, MTNL, TCIL, ITI, and CDOT, participants from industry and academic institutions. Good morning and a very warm welcome to each one of you to the today's webinar on Telecom Act 2023, organized by National Telecom Institute for Policy Research, Innovation and Training. Today, we gather virtually to explore and dissect the far-reaching implications of the Transformative Telecommunications Act of 2023, a landmark legislation that would undoubtedly shape the trajectory of our nation's telecommunications landscape. Dear participants, this webinar stands as a testament to NTIPRIT's commitment to fostering and sharing knowledge on concurrent topics of importance within the telecom and ICT domain. Our aim is to create a platform where industry experts, policymakers, and stakeholders converge to share insights, exchange ideas, and collectively contribute to the effective implementation of the Telecommunication Act 2023. We have a distinguished panel of speakers who are experts in their respective fields. We have with us Shri S.K. Verma, Joint Secretary Administration, who will be covering the general aspects of the Act. We have Shri P.K. Singh Saab, who is DDG Security, and he'll be covering security-related aspects of Telecommunication Act. We have Madam Revati, Joint Wireless Advisor, as a speaker who will be covering spectrum-related aspects of the Act. And we will also have Shri Neeraj Kumar, Deputy Director General, National Broadband Mission, who will be covering ROW-related aspects of Telecommunication Act 2023. Their valuable contributions and expertise will undoubtedly enrich our understanding of the intricacies surrounding this significant legislation, Telecommunication Act 2023. I welcome all the esteemed speakers in this webinar. The Telecom Act 2023 is not just a legal framework, it's a blueprint for the future of telecommunications in our country. It is designed to promote innovation, competition, and inclusivity, ensuring that our citizens have access to cutting-edge services while safeguarding their privacy and security. The agenda for today's webinar encompasses a comprehensive exploration of the key provisions of the Act relating to security, spectrum, and ROW, and general aspects of the Act. We encourage active participation from each of you as your insights and questions contribute to the richness of our discussions. I'd like to express my sincere gratitude to Honorable Secretary, sir, on whose behest and guidance this webinar is being organized. Sir, we would also like to convey our sincere thanks to you for sparing time and agreeing to inaugurate even during your important official visit outside Delhi. I hope this is going to be a very learning and a very rich learning webinar, a very engaging and insightful webinar. Once again, I welcome all the esteemed participants and respected speakers. Thanks, everyone. Over to you, Siddharth.
Thank you, sir. Thank you for formally welcoming our participants and the guest speakers for today's webinar. Now I invite DG NTIPRIT, Shri Devkumar Chakravarti, sir, to kindly give your keynote address. Over to you, sir.
Thank you, Siddharth, and thank you, Mr. Atul. A very warm greetings and a good morning from the NTIPRIT. NTIPRIT is very happy to conduct this particular webinar today on a very widely discussed topic, the new Telecom Act 2023, which has been enacted by the Parliament just 20 days back. NTIPRIT is equally happy the Honorable Secretary Telecom, Dr. Neeraj Mittal, though he was not in the station and he was in fact in car in Ayodhya, still he has given his address and he has given a big amount of motivation to NTIPRIT and to all the participants as well. We all know that the draft, the telecom bill, it was prepared by the Department of Telecom in 2020. Then it was placed in the Lok Sabha on 18th of December last year. It was passed by Lok Sabha on 20 December. Then on the next day, it was placed at the Rajya Sabha, and the Rajya Sabha passed it on 21st December 2023. Finally, after the signature of the Honorable President of India, it has now taken the formal shape of an act passed by the Parliament. This new act has repealed the Indian Telegraph Act of 1885, the Indian Wireless Telegraph Act of 1933, and the Telegraph Wires Unlawful Possession Act 1950. You can see that 138-year-old Indian Telegraph Act has now been replaced by a comprehensive framework, and it has been brought under a single umbrella. It is a big step towards Atmanirbhar Bharat, and as we have seen in the recent past, many more IPC, CRPC codes have also been changed, and it has been brought and aligned with the Indian perspective. This act is perceived to bring in the biggest reforms in the telecom sector in the country. Owing to the paucity of the time, instead of going into the different clauses and sections of this particular act, I'll try to just highlight some 9 to 10 important parameters which called for introduction of a new act. Normally, acts, rules, regulations, these are the long-term perspective. These are not done keeping in mind 5 years or 10 years or something in the near future. Something was definitely missing in the earlier telecom acts, in all the 3 acts, and that basically caused for introduction of the new act. I would like to highlight those salient features, what basically called for introduction of this new act. The first important point is the definition of telecom. The 1885 Act basically regulates telegraph services, whereas the telegraph services has been shut down in our country in 2013 itself. The communication technology has since evolved significantly to facilitate the real-time transmission of text, voice, images, and the video information. These have given rise to a variety of the services, including the voice calling, SMS, radio broadcasting, television, internet-based communication services for messaging and the video calling. Further, another key development has been the ability to provide similar kinds of services across different technologies. And by that, I basically mean the convergence of the technologies and the services. For example, internet services now can be offered to the cable TV also. Broadcast services also can provide the internet services and vice versa. This new act will now promote this convergence of technology and services, which was missing in the earlier acts. The number 2 point is the authorization of the telecom related activities. On earlier occasions, licenses were being granted for operating telecom services in India. Now there will be one simple authorization from the central government instead of 100 different licenses. Existing licenses will continue to be valid for a period of their grant or for 5 years, wherever the period is not been specified. Or people who are working in the LSAs, they might have faced this particular issue. Actually, the people who come to sign even the licenses for ISP, category A, category B, like that, they're not aware what we have given in the 200-page documents. Majority of the people are basically not knowing also what impact this particular lines, whatever we have mentioned there. So I think it's a significant move that now we have introduced only an authorization letter instead of a complicated licenses. Point number 3 is the assignment of the spectrum. As it is, the spectrum will be assigned by the auction route. But in specified cases, now the allocation to the administrative route also has been allowed. Now, what are those specified administrative purposes? It may be national security and defense, disaster management, weather forecasting, transport, satellite services, public broadcasting services, and etc. In addition to that, the central government may permit sharing, trading, leasing, and surrender of the spectrum. These are the very important clauses which defines the clauses of entry and exit into the telecom services. So now the entry and exit has been made simpler. And the person who is going to do a job, he knows how to exit and what could be the impact on exiting this particular sector. So these are basically seen as the propeller for increased volumes of business in the telecom services in the country. Number 4 point is the power of interception and search. The Act provides that existing rules will continue to be enforced. However, an additional clause has been added now, which will allow the government to go for mass surveillance. That is very important. And this case is related to the national security or maintenance of the public order. This is a very important thing. You might be knowing on the earlier occasion, we have been asking for a tower done from the TSPs. They don't provide. They say that it is not as per the license conditions. And they give us a suspected list that you trace out from that whether there is an illegal operation or there is a clandestine operation like that. Now, all data, all traffic data will be supplied by the service providers to the department. And if we can generate the best of the algorithms, best possibly it will be an automatic detection of those illegal operations or the clandestine setups like that. I think the telecom network is going to be much safer and free of the cyber crimes tomorrow. Number 5 important point is the right of the way. Entities laying the telecom infrastructure, that is the service providers, they may seek right of way over the public and the private property. What has happened on earlier occasion, the government operator, either it was the DOT or subsequently the BSNL, MTNL, they used to get a priority over getting allocation of the right of ways on the public property as well as in the private properties. Now everything has been brought aligned. Everybody has equal right to seek ROWs, and ROWs will now be given on a non-discriminatory and a non-exclusive basis. That makes it a perfect judicious decision of the government. Number 6 important point is the Digital Bharat Nidhi. We all know about the USOF, the Universal Service Obligation Fund for unserved or underserved areas of the country. The bill, the new act, retains the provision of USOF, but now it renames the fund as Digital Bharat Nidhi. And it allows now making expenditure from that fund for the research and development in the telecom sector. It's a very, very important thing because when the USOF was introduced, there was a huge requirement of covering the undercovered or the uncovered areas. By now, majority of the areas has got covered. Now the time to spend this money is for the R&D activities in the country so that we can become the lead country in the 6G. We can become a manufacturer in 6G. So it is very important that the money is spent basically for R&D purposes. It's an excellent step basically towards strengthening the R&D activities, innovation, and startup promotions. The important point number 7, the offenses and the penalties. Whoever has worked in the field, in the LSAs, all the officers have been talking since last 4-5 years that the very easy availability of SIMs has been the root cause of nuisances and fraudulent activities through the telecom services. Now, a stringent requirement of user verification has been mandated for. Obtaining a SIM or other telecom services or resources through fraud, impersonification, or cheating will result into a jail term up to 3 years or a fine up to 50 lakhs or both. So I think tomorrow we'll be finding that the users are valid, genuine, and that will basically impact towards a safer network. Point number 8 is also equally important, that is the adjudication process. So it was a bit surprising that DOT is the nodal department or the ministry for the Telecom Acts. but we do not have any mechanism to ensure at least the civil offenses that they are tackled by us. In every department, you will be finding they have a body within the department they tackle about that, look into consumer affairs or look into any other ministry. So for the first time, the first level and the second level of adjudication over the civil offenses under this act has been given to the Department of Telecom, a joint secretary level officer with the first level adjudication, and there is a designated appellate committee which will be headed by an additional secretary level, where an appeal can be made to this committee within 30 days or so. Even designated appeals committee, a decision of that can be challenged in the TDZ within 30 days, and we know that TDZ things well can be challenged in the Supreme Court. So I think now the entire matter has come under a 4-layered strategy, and because many of the things can be handled internally within the department, the cases or the civil offences will be disposed much faster, and gradually we will see the impact that civil offences are coming down in the country. Finally, I have a very important point to raise. I think the OTT players, the over-the-top services, especially those who provide the communication services like WhatsApp, which is owned by Meta now, Telegram and Signal, they have not been covered under this act. And I really appreciate this particular thing because for the last, I think, 7-8 years, everybody has been discussing whether OTT should be brought under the act, it should be brought under the regulation or so. Finally, the government has not covered it. By not covering what it has given a message, actually OTT is a sheer innovation. It's a sheer innovation. If you bring it under regulation, bring it under the provisions of the act, you'll be basically blocking the faster growth of that. Another point, in India, OTT has yet to grow the way it has grown in the developed country. The market is much virgin till now. I think we require that adequate volumes of business and services grow up, and subsequent period it may be re-looked into. Summing up, I think the new Telecom Act defines the sector better. It brings in clarity. It has simplified the licensing regime. Spectrum allotment mode has been made more rational and made very much connected to the national issues. It helped foster creation of infrastructure. It helped foster disposal and reduce the civil offences under the Act. It checks misuse and fraudulent activities. It propels competition through the easy entry and exit clauses, gives trust to the R&D and innovation in the sector, and finally addresses the national causes and security much better. I think it's now time to give this act to get operated over the country for the common good of all the citizens and the government of India. Thank you very much.
Thank you very much, sir, for your address. You have set the tone for further deliberation in the technical sessions. Now we are at end of this inaugural session. Without taking much time, as we are already delayed, I invite the first speaker for today's session, Shri Sunil Kumar Verma, sir, who is Joint Secretary in Department of Telecommunication. He will take the first session on general provision of this act. Sir, you are requested to kindly share your screen.
Yeah. Good morning, Niji sir and Atulji and all the participants for giving me this opportunity to share with you all the general provisions of the Act. I have been involved with the making of the bill and the documents associated with it. So I will share one thing that this Act has seen a day because of the great efforts of our Honorable Minister and our Secretary, sir. There was a lot of efforts, day and night efforts for making this happen and see the day of the light. Before going further, I will straight away go to load the presentation.
Please.
If I share open system setting, record is. That's not been.
You can share your screen.
Windows.
Entire, sir, share entire screen.
Entire screen. No, it is content is presenter.
सर आपके पास है प्रेजेंटेशन
Sir,
एक मिनट
अपलोड कर
हाँ
दीजिए
तो
अगर
आप लोड हाँ
sir, I can share the presentation from my side, sir. Okay.
okay you please
वर्मा जी हम लोग यहाँ से शेयर कर देते हैं आप केवल नेक्स्ट स्लाइड बोलेंगे तो हम लोग यहाँ से नेक्स्ट स्लाइड कर देंगे
okay right thank you so you please go to the slide directly
Yes.
yeah please
I hope the slides are visible, sir.
it
yes
is
it is
visible to
Siddharth. Yeah.
So this I will straight away go to this first slide. Why there was a need for a new law? Because the earlier speakers have already mentioned that we had three laws. The first law being as old as 138 years old. And almost lost the significance with respect to the development what has happened in these many years. It was a Telegraph Act 1885 and Wireless Telegraphy Act 1933 and the Telegraph Wires Unlawful Possession Act 1950. The reason for the new law was that the definitions, the nomenclatures, they were very old. There was no provision for a spectrum. The right of way provisions were not strong. The only provisions were made for the telegraph lines, optical fiber, or the mobile towers. They were not covered in the earlier acts. The regulations were very complex. Ease of doing business was missing, and offense and penalties they were not effective, of course, because they were very old. The nature of telecommunication, its uses and underlying technologies have gone massive change. The telegraph era has gone, and now the optical fiber, mobile, these small cells on the street furnitures, now they have come. Instead of the metallic wires, now we have fibers, microwave, satellites, and all such communications. Next, please. Next slide, please. So, in the process of making this bill, these are the important stages we have crossed. We consulted and we compared the such laws and acts in the other countries like Australia, UK, European Union, Singapore, Japan, and US. And then the first consultation paper was released in July 2022. The draft bill was first published in September 2022, and the consultations were held. The remarks and the comments were received from 60 ministries of the Government of India, 35 various associations, 7 TSPs, ISPs, 32 firms, and 700 plus other individuals. They also submitted their comments. Next, please. Based on that, the bill was finally prepared, and the important features of this Telecom Act are, I will cover each of the item further just to have a brief idea that it has a simplified regulatory framework. And we are now talking of authorization instead of licensing. A specific provision for a spectrum which was missing in the earlier act. And for right of way, there is a very effective framework because the first right of way rules, it was issued in 2016 by DOT. And there have been subsequent revisions in 17, in 2022, and in 23 also. So in this Telecom Act, we have tried to cover the right of way. The sole purpose was for the faster expansion of the telecom infrastructure. And there have been made a strong provision for national security, public safety, and public emergency. The universal service obligation from the scope of this fund has been expanded further. Next, please. There has been provision for protection of users, and there has been effective provision for penalty and the offenses also. And there have been a provision for promoting innovation through regulatory sandbox. And the one new thing has come regarding this voluntary undertaking mechanism. The purpose is to reduce the litigation in the courts, and also it will create a kind of ease of doing business and ease of living. And for that, there is a pair on alternate dispute resolution also. The language has been modified greatly. It has been made a very simple language in the act. Normally, if you see the normal acts, the language is very complicated. And if you read the Telecom Act, then you will feel as if you're reading a normal book. So, and a lot of efforts have been gone in this process for making the language very simple. The contextual definition is another feather in the cap. So if you talk of the regulatory framework, so all the license, registration, permission, they have been replaced by authorization. It also indicates a shift in the mindset, what we want to inculcate in our organization, that we have to think of the ease of doing business and ease of living in all the activities, in all the actions what we take. There have been provisions of light touch terms and conditions for some services where we do not want to regulate in a big way. To prevent disruption, existing licenses and registration and permission, they will continue till their validity period. So that it should not happen that once the act come into existence, suddenly there is a kind of hue and cry and people start facing problem. Rather, they should face ease in the transition of the act from the earlier to the new one. The existing exemptions, what have been given, they will continue. And there is a saving clause for laying transmission lines under Electricity Act, again, with the reason that there should not be a kind of disruption in the existing services. Next, please. This has been the most important, we should say, the feature of the Telecom Act, because in fact, this can be the basis of the new Telecom Act, because it was all started with a spectrum only. Because it is a very big issue, and we all know that it is a very, very important issue also, and it has a wide ramification implication in public. So this was the basis how this telecom bill started. So it was a first stage. In the bill, what has been covered, I will just cover in one slide, because this topic will be covered in detail by Revati Madam subsequently. In this spectrum, we say that it will be assigned through auction, except the cases mentioned in Schedule 1. There is a Schedule 1 in the Act in which we have enlisted some 19 entries, wherein we will go for the administrative assignment. Otherwise, we will go normally the auction mode for the assignment of the spectrum. The Schedule 1 has items which are based on public interest, government functions like defense, space, transportation, police, and where auction of spectrum is not the preferred mode due to technical or economic reasons. We have a very clarity in the Act, wherein when we say that we will go for the administrative assignment, then it should be get fit in these kind of brackets. And there is a provision for the efficient use of spectrum. There has been a para on harmonization, reforming, secondary assignment, technology neutral use, leasing, sharing, trading, all for the purpose for the efficient utilization of the spectrum. And there is also provision for the flexible use of spectrum. Another provision is for taking back the spectrum by the government in case it remains unutilized. Next, please. This has been very important, another very important chapter in the Telecom Act, this right of way. It really affects all the infra providers, and I mean, a very large, I should say, the portion, I mean, persons who are associated with the telecom industry and the telecom infrastructure development. There is a concept which has come up in this bill is of a public entity. Public entities, they include government agencies, local bodies of the state, public facilities, airport, highways, metro, housing society, malls, they all have been declared as a public entity, and the scope has been broadened. And public entities, they will permit ROW in general, except in the rare cases. So because the ROW requirement is more in public places, and with the inclusion of public entities in the Act, we believe that expansion of the telecom infra will be now at a much faster rate. Further, in private properties also, a provision has been elaborated through mutual agreement, because in the absence of it, it was a kind of different methods were followed by different operators or the infra providers, and there was not a uniformity kind of thing. Now it has been since legislated, so it will give a base platform where from the people can make a mutual agreement, and in public properties also the ROW will move faster. Next, please. Uh, Again, this it has to be non-discriminatory and non-exclusive. Slightly, I will just explain, because suppose in a apartment, in a mall, one operator comes and he lays the fiber, and the other operator come, he also wants to lay the fiber. Then the owner will not discriminate. He will follow the same terms and conditions, and will give a equal platform for all the operators, so that we will have a choice. Either they can use either of the TSPs. I will not name, but they will have the facility to choose the operators, or to choose the infra providers. This the second para is very important, because there have been issues with some states wherein the telecom network has been treated as a kind of property. It is a kind of coming in the jurisdiction of land, which is the state subject. So there have been issues with this. So in this act, it has been made very clear that this telecom network will be distinct from property. It will not be treated as a kind of land subject, which is within the ambit of state government in the constitution. The another one is the policy for common duct and common corridors. So by coming in the act, I must say that when we see that in cities, in other than cities also, every time there is a road cut for laying one cable. For one operator comes, he cut the road. Then another operator comes, he also ducts the road. So this kind of problem create difficulty for the citizen, ordinary citizens, as well as for the infra providers also. Because for a small work, they have to bear a lot of cost and a lot of time, lot of permission taking for all these activities. So there is a concept for cable duct. This cable duct will be for provision of this cable duct, the government will notify the projects, the in which the common duct and cable corridor will be an integral part of the project. Say, for example, a road is coming, or a bridge is coming. So this duct and corridor will be made as a part of the infrastructure of that road. And for management of that duct, there will be a body kind of which will manage it and provide access to this duct to different various infra providers on a non-discriminatory and non-exclusive basis. Uh, the rules will be framed. It is a concept which has come up in the Act. The rules will cover all the issues which will be required to be covered in this handling of this duct and cable corridors. And one very important part of ROW is the dispute resolution mechanism, and it has been kept at the district level. So, for example, if any grievance comes, if someone suppose a cable has been laid through through a private property, the property owner has some issue with the infra provider. So if the grievance comes up, so it will be settled at a district magistrate level. So he need not go outside his area, and it will be settled, and also a kind of litigation in the court will be avoided. If there is an issue of compensation, so this will be settled at the district judge level. So again, effort have been made that a citizen should be confined to his district's level only. He did not move here and there for settlement of his resolutions. Next. The issue of standards, notification of standards has also been covered in the bill, in the act, for this telecom equipment, network, identifiers. This identifier is also a new concept, it has come up. Telecom service in consonance with TRI, because TRI has been giving direction and they have some jurisdiction also. For production, for import, export, sale of the telecom equipments, in field of telecom security, cyber security, encryption and data processing. For all these, the government will notify the standards. Next. Next, please. There have been provisions made in the Act for dealing with public emergency and public safety, wherein there is a provision for taking temporary possession of network. It means that if there is an emergency, the government can take the network of any TSP temporarily during that period by following all the relevant rules. They will all will come up in due course. And in such situation where there is a requirement of priority call routing, this will also be done. Of course, for interception and suspension of services, already there are provisions in the Act, and in the new Act also, these will be done strictly as per the judgment of Honorable Supreme Court and in compliance with the constitutional provision. And this is press messages normally will not be intercepted except if there is a requirement in case of public emergency and safety and within the constitutional framework. Next. National security, yeah, this has also been covered in the Act. Central government can give direction based on national security and the friendly relations with the other countries or at the time of work. There is a provision for trusted sources for procurement of equipment or services. I mean, this telecom network, as we all know, they are very sensitive. And I should say that the security, security of a country is now very linked with the telecommunication infrastructure. Because at the time of cyber attack and war, the first place which is attacked by the enemy is the telecom infra, because it plays a very vital role. So the trusted source environment is a very important kind of issue which has been made in this. So for any telecom infra, we require a kind of trusted source certification from. I mean, we cannot procure it from the countries, land border countries, kind of where we have issues. Then there is provision, then taking over of telecom network and access services, as I covered in the earlier slide. Next, please. The Universal Service Obligation Fund, we all know it was existing since 2012-13. It has been named now Digital Bharat Nidhi. The scope has been widened. Earlier it was rural and remote areas. Now the underserved urban areas have also been taken into account. So there are pockets in urban areas also where the adequate infrastructure is not there, and we feel that it should be covered, and we should fund the viability gap for providing telecom infrastructure in those areas. And one important is for research and development for the telecom services, technology and products, there is a provision. There is a kind of 5% of the total annual collection under this use of fund allocated for this R&D, subject to some selling. And in this now pilot projects and new technologies have also been included. So this will now be used for research, development, innovation, all these things. And one new concept has come up for regulatory sandbox to promote innovation. This regulatory sandbox is basically, it is a live testing environment where new product, services, processes, business models, which may be deployed on a limited set of users for a specified period of time with certain relaxation from the provisions of this act. For example, if you say, if you want to test a kind of say 5G, you have developed a 5G equipment, 5G service providing equipment. So if you want to test it, so you may need say 5G spectrum. You may need some area where you can have callers and all those things. So there will be a sandbox where there will be a facility for, you need not go for taking spectrum from the government. Everything will be available. You just go, fit in your equipment, test it, get the result, get the test report, which you will use further for either commercial or for any other reasons. So this will help actually faster the innovation and the research and the development. Next. There have been provisions for protection of users also, because we have learned so many cases wherein the Aadhaar of somebody else being used for issuing SIM for somebody else, and that person doesn't know that his Aadhaar has been used. So now it has been made compulsory that the KYC will be only through verifiable biometric identification, so that he is aware that a SIM card is being issued and there is no fraud which will take place. There is a protection from unsolicited communication, in which the prior consent of users, it will be obtained by the telecom operators before sending such messages which are of commercial nature. So this will help users in protecting their interest. There is an online grievance redressal mechanism. If all this redressal mechanism will have to be provided by all the operators, whoever is providing this telecom services, he will have to provide this facility of online redressal. And along with the rights, there are certain duties of the users also, like they will not submit any false kind of certificate or document for acquiring a SIM or acquiring any services. So there are certain duties which have been prescribed in the bill. Next, please. This is a very new thing, voluntary undertaking and alternate dispute resolution. Uh, there have been provision of adjudicating and appeal mechanisms for breach of terms and condition of the authorization. The voluntary undertaking mechanism with lesser penalties and mitigation measures have been provided in the Act. When a business makes mistake, so it should be given a chance to rectify it and move on after paying a requisite penalty. It does not mean that we are promoting that you do some fault, mistake and pay the penalty. No, there are mitigation measures also. Suppose somebody comes that yes, I have committed a mistake, even though government has not noticed it. The entity may come to the government and they may say that we have committed a mistake, or we have committed something breach of kind of terms and condition, and these are the mitigation measures which we propose. Then the government will examine it, and the after examination and finding satisfactory, the respective, penalties or lesser penalties will be imposed accordingly. There is a complete kind of a complete structure in this. And depending on the factors relating to the contravention, the penalties have been graded. It is not that for all the penalty there is a single punishment. So it has been graded based on the gravity of the offense, gravity of the breach. The penalty will be imposed. It varies from written warning up to a fine of rupees 5 crore. In one more thing I would like to discuss in those adjudication mechanism, that there have been level of say, one is the adjudicating. Please go back to the earlier slide. Yeah, thank you. So adjudicating officer will be a level at the level of JS and above, and there will be a appeal designated appeal committee which will be notified by the central government, wherein additional secretary and above officers will be there. And after that there will be appeal with TDSET, Telecom Dispute Settlement and Appellate Authority. So there are, if you say, there are 4 layers of dispute resolution, starting from voluntary undertaking to adjudicating officer to designate appeal committee and then finally to TDSET, so that people are, I mean, again, it will increase ease of living, ease of doing business. Next, please. For offences, the provisions made in the Telecom Act are civil penalties for violation of terms and condition of authorization. There have been a strong punishment for offences committed by unauthorized entities, and 5 offences have been listed with maximum fine of 2 crore and maximum imprisonment of 3 years to the entities, to the providers, service providers. All offences are cognizable and non-bailable. It also applies to abatement or attempt to commit or conspiracy to commit such offences. Next. Some other provisions have been made in the TRI Act to widen the pool for eligible candidates for the post of members and chairman of the TRI. There have been some certain relaxation have been made in the Act. And this predatory pricing, it has been talked in media in the past. So TRI has been given powers to regulate this sector, kind of. And the most important part is that implementation of this act, whether it is any dispute resolution or otherwise, it has to be digital by design. So for this implementing this digital by design, a set of rules will come up, and the department will try its best that all possible steps are taken so that the technology use is really made of, and all the implementation and all the possible action, whatever is done, it is digitally, so that people can work on it, use it, sitting from home, and ease of doing business and ease of living really makes sense for making this digital by design. Next. These are schedule 1. I just am covering it for the information of the audience, that these are the areas, these are the entity, these are the entries which have been mentioned in schedule 1. These are national security, defense, law enforcement, crime prevention, public broadcasting services, disaster management, safeguarding life and property, promoting scientific research, resource development, exploration. For all these, we do not require a kind of bidding, a kind of auction. It will be all assigned through administrative assignment. Safety and operation of, we all know that road, railway, metro, regional road, inland waterways, airport, all these things. Then conservation of natural resource, wildlife, meteorological department, and weather forecasting. List continues. Go to the next, please. Internationally recognized dedicated bands for amateur station, navigation, telemetry, used by central government, state government, their entities or authorized entities for safety and operation of mines, ports and oil exploration and other such activities where the use of spectrum is primarily for safety and operation. Then mobile trunking radio services, radio backhaul for telecom services, community radio, in-flight and maritime, space research and application, launch vehicle operation, ground station for satellite control. And the third list is also there. Third slide, sorry. Next. The satellite-based services such as teleports, television channel, direct to home, and all these things, mobile satellite services in L and S bands used by central government, state government, are their authorized agencies for telecom services. This BSNL and MTNL, and testing, trial, experimental, demonstration purposes for enabling implementation of new technologies, including creation of regulatory sandboxes. So these are all the entries for which administrative assignment will be done. Now, at the end, I would like to just share 1 or 2 more things, that the Act has been notified in the Gazette. Now there will be a notification for the when the different provisions of the Act will come into force. So that will take some time for getting this Act into force. In the meanwhile, the important activity of formation of rules is already going on, and we are already in the advanced stage. So after the rules are framed, the rules will also be notified in the due course. They will actually guide the implementation of the Telecom Act further. Thank you. Thank you for giving me the opportunity.
Thank you, Mr. Verma. Thank you very much for a very comprehensive coverage of the entire Act. And you have very nicely dwelt with all the provisions of the Act and the specific provisions relating to ROW security and the spectrum would be dealt by the subject matter experts. So I thank you once again for addressing this huge gathering. We are very encouraged by the large number of participants who are present here. Almost more than 600 participants are participating. Thank you, Mr. Verma, Joint Secretary Administration. And now I think Mr. Neeraj Kumar, DDG National Broadband Mission, he is in Ahmedabad for attending that Vibrant Gujarat program, and probably he has a presentation in next 1 hour. So, Madam Revati, we beg your excuse for just changing the order. Mr. Neeraj Kumar would give his presentation for the next half an hour so that he can be free to move to the next presentation in Vibrant Gujarat. Over to you, Mr. Neeraj. You can share your slides.
Yeah. So, sir, Neeraj, sir, I'm sharing your slide. Just a second, sir.
You will have to say next and next, Mr. Neeraj. Whenever you want, you can say next. He will make the next slide now.
Thank you, Mr. Atul Sinha and Madam Revati, for giving me priority because I have to rush from hotel to the Mahatma Mandir venue of the Vibrant Gujarat Summit, and there I have a session at 2:30. So thank you very much. So I will be covering the right of way, which is in the chapter 3 of the new telecom bill. Now it has become the act. Some of the feature might have been covered by JST, Mr. Verma, but anyway, I will try to touch down those also. Next, please. So, as you know, that this act basically is a single telecommunication bill 2023, which incorporates the Indian Telegraph Act 1885, Indian Wireless Telegraphy Act 1933, and Telegraph Wireless Unlawful Possession Act 1950. Next. So the main thing about the right of way are basically there is a separate chapter. Clauses are from 10 to 18 to simplify the process of getting right of way, and now the important thing is that grant of right of way to be non-discriminatory. For example, in Delhi airport now they cannot say that I will only give access to Airtel. So now it has been brought into the law. Similarly, non-discriminatory means also the charges they cannot discriminate. Non-exclusive means they cannot say that only I will give to Airtel or Jio. So as far as practicable is written there in the act, so technical feasibility should be there. And there is a mechanism of dispute resolution for damage to the telecom infrastructure. So these reforms are basically aimed to bring down the cost of deployment of the telecom infrastructure and reducing damage to the telecom infrastructure. District magistrate or any other authority has been notified, which will be notified by the central government, will be given exclusive power to resolve disputes under this chapter, except for matters related to compensation. Regarding compensation, district judges have been authorized, and determination by the DM or district judge will be treated as final. Next. So what are the things covered? Definition of public property is covered there. ROW charges and timelines. ROW application process for telecommunication network in private property, which means other than public property. Telecom infrastructure and property taxes. Whether what is to be done if there is a coercive action by local bodies. ROW application rejection methods. Removal, relocation, or alteration of telecommunication network is also touched upon, and the owner's right to give notice to facility provider for likely damage to telecom network during his use of his own property. and power has been given to central government to establish common ducts and cable corridors. Next. So these are the things I will be covering one by one. So the important definitions which are available in the new act are basically, the most important one is the facility provider. So facility provider means the central government or any authorized entity. That means telecom service provider, infrastructure service provider, or ISP, or any other licensee, they will be covered and called as facility provider. And it will also include any contractor or subcontractor or agent working for the central government or these authorized entities. So property definition has also been categorized. So public properties has been defined. So any property which is owned by public entity, and public entity means central, state government, local authority, any institution, or and any apart from this, any government entity managing public facility can also be notified by central government as public property. And the properties which are not covered in this definition, they will be treated as private property. So that means private property which are other than public property. Next. So the important thing is, earlier the timelines were not backed by any act, though ROW rules 2016, and later on we said that the ROW application should be cleared within 60 days. But these rules were to be adopted by each of the state. But now when it comes into rules backed by the act, now they need not be adopting these rules, because this will be a central, they will be backed by central act. So the new bill provides for this clause 11(3). ROW permission are to be granted within timelines which can be prescribed by the central government. So now timelines can be defined by DOT. Apart from this, even the administrative expenses and compensation for right of way shall not exceed which may be prescribed. Though we had also prescribed these tariffs under the ROW rules, but now all these tariffs will be backed by the Telecom Act. Third point is that rejection shall be based on reasonable grounds to be recorded in writing by the rejecting authority. So earlier there were, I think, hundreds of reasons to reject the application, and in many cases they will simply say that radiation is more, or they may not specify any reason. So during the last 1.5 years, though we had reduced the reasons of rejections to around 20 plus 24 or so, from 200, but now these 24 also, they are backed, they will be backed by this act. And for any damage caused by the facility provider, so either he will restore such property or pay compensation as may be mutually agreed. So there are two options, so either restore or pay compensation. But this option, whether to ask the facility provider to restore or take compensation, will rest on the public entity. Another point is that facility provider can enter property for survey and maintenance also, prior to installation survey and after installation for maintenance. Next, please. So regarding the ROW on property other than public property, that means the private property, there was no clarity on right of way, what will be the procedure to get, and how, what will be the procedure to apply. So now apply. So new bill or new act now provides for application process for ROW on property other than public property, that means private property. Mechanism can be defined by central government by defining to submit an application for ROW for telecom network to the person under whose ownership, control or management of such properties vested. मतलब जो उसका owner है, उसको किस प्रकार से application submit करना है, that can be defined. And subject to mutual agreement with the facility provider for consideration for survey, maintenance and damage. So this can be mutually agreed कि सर्वे के लिए कितना पैसा वो पार्टी लेगी, मेंटेनेंस के लिए कितना लेगी, डैमेज टू हिज प्रॉपर्टी के लिए कितना पैसा लेगी. In case when the entity fails to provide the ROW requested, suppose कि वो application देने के बाद ROW का नहीं permission देता है, then central government in the public interest can determine either by itself, या तो खुद से decide कर सकते हैं, or through any other authority designated by it, that such facility provider shall be permitted the ROW subject to terms and conditions. That means कि क्या charges लगने हैं, ROW लगने, compensation whatever, but वो उसको ROW permission देना होगा. So this basically addresses the challenges faced by all the telecom service providers in streamlining processes. पहले बहुत सारे इवन जो सरकारी PSUs थे, they used to say कि साहब हमारे पास तो कोई rules applicable नहीं है. Then we had to take up the issue with them individually. जैसे कि SAIL है, BHEL है, defense का land है. So gray area was there. So now they will have to process the application within the prescribed timeline, capping charges and facilitating the deployment of telecom infrastructure in public land as well as in private property. Again, in a non-discriminatory manner and as far as practicable on a non-exclusive basis as per the clause 13. Next. So another big nuisance was the property tax in Chennai, Maharashtra, Tamil Nadu. The authorities used to take even up to 250% of the building property tax, and they used to say that we are not taking from the telecom service provider, rather we are taking from the property owner. But again, property owner will pass on this to the service provider, and we have lost a case in case of Chhattisgarh. Even in Supreme Court said that this is the legal right or sovereign right of the state or municipality to impose tax. So DOT is preparing to go to court. I don't know the current status, but if we had lost in Supreme Court, then it would have given a cue to everybody, every municipality in the country to levy property taxes. So now the new bill provides that a facility provider shall have only the right to use the property. पहली चीज तो ये है कि telecom service provider या ISP IP का भी they won't have any other right on the property. Second part is telecom network installed on any property shall not be subject to any claims, encumbrances, liquidation or like relating to such property. मतलब उसका property के ऊपर कोई अधिकार नहीं होगा. Third point is कि जो telecom network है, that shall not be considered part of that property for any transaction. Suppose उसको property बेचना है तब भी वो उसका part नहीं होगा, और उसमें अगर कोई property tax लगना है, levy, the government wants to levy any cess or taxes or duties, so this telecom network will not be considered part of the building. So this is now clearly defined. So this serves and settles a lot of issues for the telecom service provider. Next. Yeah. So another nuisance which our telecom service provider used to face was that whenever any officer of the state government or municipality on the pretext of beautifying, and Karnataka, Maharashtra, Tamil Nadu, West Bengal are the example. In Karnataka, they have cut a lot of optical fiber cable, Airtel, Jio, and everybody, they were complaining profusely, and we used to arrange meeting of the Secretary Telecom with the Chief Secretary. So they will simply cut, even the towers were cut. So now this says that no authority will take any coercive action, and it is also defined: sealing, preventing access or forcible shutdown of telecom network established by an authorized entity. It is important to know, authorized entity. इसमें कुछ exceptions भी हैं. For example, अगर परमिशन किसी ऑथराइज्ड ऑफिसर के थ्रू मिली है उसको सील करने की, सेंट्रल गवर्नमेंट नॉमिनेटेड, दैट मींस डीओटी के अफसर के थ्रू अगर परमिशन मिली है तभी ये काम हो सकता है, अदरवाइज नहीं हो सकता है. और देयर आर एक्सेप्शंस इन केस ऑफ नेचुरल डिजास्टर्स और पब्लिक इमरजेंसीज, या इसके अलावा कोई और लॉ है कंट्री का जो कहता है कि सब ऐसा एक्शन लिया जा सकता है टू कट द केबल और कट द टावर, देन ओनली लोकल अथॉरिटीज कैन basically take such coercive action, otherwise they cannot take this coercive action. So this, in my view, will enhance the network integrity and will contribute to stable business environment. Next. This is an important provision which was not mentioned, and we used to get complaints regarding this. For example, there is a road being built by Border Road Organization, and they want to shift all the cables which are there in the middle of the road. So they will simply ask you or even cut the cables. So first of all, they cannot take coercive action, they cannot cut. Secondly, even if some authority wants that the optical fiber cable should be taken now beyond the center of the road or beyond the edge of the road, there was no compensation was being paid to these authorities. So every time the telecom service provider or ISPs, they used to basically lay or shift the cable again on their own cost. And if they will have to lay it at maybe a distant places, again they will pay for the damages or restore the roads. But now this says that in case any authority asks facility provider to undertake relocation or alteration, that means in such a situation the property owner will bear the cost of removal, relocation or alteration, and iska cost jo hoga, that will be mutually agreed. But this will be applicable only in case the compensation for damages was given by that facility provider during initial installation. कि पहली बार में दिया था, अब उसको शिफ्ट करने को कोई अथॉरिटी कह रही है, तो उसका रिलोकेशन का चार्जेस उसमें देना पड़ेगा. अगर इस रिलोकेशन के केस में द फैसिलिटी प्रोवाइडर डज नॉट कंप्लाई, कि वो एग्री नहीं होता है रिलोकेशन के केस में, देन प्रॉपर्टी ओनर कैन अप्लाई टू डिस्ट्रिक्ट मजिस्ट्रेट who will decide relocation or alteration. Then dispute जो है डिस्ट्रिक्ट मजिस्ट्रेट के पास जाएगा कि उसको शिफ्ट करना है कि नहीं करना है और कहाँ पे करना है. तो ये तो एडमिनिस्ट्रेटिव हो गया. लेकिन अगर कंपेंसेशन म्यूचुअली एग्री नहीं होता है, then the compensation will have to be decided by the district judge for relocation and alteration, and determination of dispute by the DM or district judge will be final as per clause 18(3). Right. Next. This section is clause 17. This is similar to the previous one जिसमें relocation की बात की गई थी, but now here it says that maybe relocation is not required, but the property owner wants to use his property in a manner wherein there is a prospect of damage of the optical fiber cable or maybe micro tower, whatever is there. So it is a genuine case of his exercise of his right to deal with his property in a manner which may cause damage or interrupt or interfere with the telecom network, which has been established under the provision of the Act. So he just can't go and start using his property which can have potential to destroy the telecom network. He will have to give a notice to facility provider, central government or any authority which is notified by the central government. And then facility provider will have to respond with details of his telecom network कि मेरा optical fiber कहाँ पर पड़ा हुआ है, and what are the precautionary measures which are to be taken by the property owner. But इसके कुछ exceptions भी हैं. For example, in case of bona fide intention of averting imminent danger of personal injury to himself or any other person, कि उसको ऐसा लगता है कि मुझे कुछ इंजरी होने वाली है, ये सपोज टावर गिरने वाली है, किसी और ह्यूमन बीइंग को उसका इंजरी हो सकती है, then he can do away with the notice. He can parallelly take action whatever he deems fit. But for example, उसने notice दिया और there is a dispute between the property owner and again the facility provider. So this dispute resolution in case of non-compliance of this provision by property owner, suppose उसने notice दिए बगैर खोदना शुरू कर दिया, then the facility provider can go to district magistrate and request him to take remedial action. And DM can take two action. First of all, he can issue an order forcing this person to abstain from dealing with such property for up to 1 month. कि आप इस property में कोई disturbance नहीं करोगे, जो आप करना चाह रहे थे, खुदाई करना चाह रहे थे, कुछ करना चाह रहे थे, you can't do it. Secondly, he can also direct to take such action as may be necessary to prevent damage, interruption, interference or telecom network. तो ये दो action है. पहला है कि कुछ आप खुदाई कर ही नहीं सकते. सेकंड में ये है कि खुदाई आप कर सकते हो, but in a manner which does not do any damage or do any interruption, interference to the telecom network. And again, any dispute in relation to compensation or damages shall be determined by the district judge. Next. Next slide, please. Yeah. So another provision in the Act is about the common ducts and cable corridors. So here it is said that central government may notify infrastructure projects or class of infrastructure projects whether by public entity by itself, कि सरकारी कोई एजेंसी उसको ले कर रही हो, or they are being executed through PPP mode, that the public-private partnership mode, or by any other person that may require establishment of common ducts or conduits or cable corridors for installation of telecom network. So in all these cases, now we can say that you will have to lay a common duct. So, and this will basically promote open access for the facility providers. And this has been done because you know that common ducts is as advantageous and comparable like metro rail. Whatever benefits you see from metro rail, you can see from the common ducts, because now frequent digging will not be there. It will decrease cost for the nation. Multiple ROW permissions won't be required. Everybody will have digital ready infrastructure. It will improve the aesthetics, and it will be environment, because dust will not come up again. Next. So that's all from my side. Thank you very much. Any questions you may ask?
We request audience to raise hands if they have any question. We will authorize you to ask questions, or you can also type your question in the message box. If on ROW somebody has question, Siddharth, can you please authorize Mr. Vikas Guru?
Yes, sir. Mr. Vikas, you can ask your question.
Mr. Vikas, you can open your mic and ask your question. Mr. Vikas Guru, please unmute your mic. Your mic is mute. We have authorized you to unmute your mic.
Yeah, thank you. Actually, it took some time to get mic
No issues.
activated.
Yeah, please.
Namaskar, Neeraj sir. I am Vikas Guru. Sir, my question is on DM and DJ's decision in case of disputes on ROW will be final. That was said, and that is into Act also. So, is there any further legal remedial action any aggrieved party can take if they are not happy with what does this final means? We cannot go to High Court or Supreme Court or anywhere else after this, or there is a proper legal appeal mechanism also existing. Thank you.
No, whatever mentioned in the Act, I have mentioned that what you are asking will have to take the legal opinion. But this is what mentioned.
Sure, sir. So I hope that that will be more clearer in rules which will come up after this.
But this basically solves your 99% problem, because
of course, sir.
Now local officer will be authorized and he knows how important the telecom is. So
Right,
you
sir.
will not have to rush to the High Court and TD said. So your cost of the litigation will also go down.
Right, sir. Right, sir. Thank you very
So
much.
the
Sir.
idea is to involve the local stakeholders in the development process.
Sure. Sir. Thank you, sir. Understood. Thank you.
So, Mr. Guru, as of now, the Act provides that it has to be dealt at that level only. That's the final. If something comes in future, probably that could be seen further. But then as of now, they are the final authority.
Sure, sir.
So,
thank you.
Mr. Vikram Tewatia, a well-known name. Mr. Vikram Tewatia, please unmute your mic and ask your question. Mr. Vikram Tewatia, can you please unmute your mic and ask your question? You are on mute. Mr. Tewatia, you are mute. Please unmute your mic. Siddharth, I think he is authorized to unmute his mic.
Yes, sir.
You're
Yes,
still on mute.
You have to unmute yourself.
Sir, meanwhile, we can take question from Naveen Thaduri. You can unmute.
Mr. Vikram, yeah, Mr. Naveen, please.
Rather than a question, it is my remarks regarding Section 18. the district magistrate or any other authority as notified by the central government within whose jurisdiction the property is situated shall have the exclusive jurisdiction. तो इसी सेक्शन 18 में सर सबसेक्शन 3 में ये कहता है एवरी डिटर्मिनेशन ऑफ ए डिस्प्यूट बाय अ डिस्ट्रिक्ट मजिस्ट्रेट और डिस्ट्रिक्ट जज अंडर द सेक्शन शैल बी फाइनल. इसमें थोड़ा लैंग्वेज में मैं देख रहा था कि जैसे सेक्शन 1 में हम ये कहते हैं कि एनी अदर अथॉरिटी, so section 3 में हम ये any other authority को हम we are not referring to that in we may explicitly provide that also so that
Okay.
the language. Thank you, sir.
I think that will be covered in rule, Mr. Naveen. I mean, that would be clarified in the rules. If central government thinks that some other authority should also be specified, probably in rules that would be specified.
Thank you, sir.
Mr. Tivatia, can you please try to unmute your mic? No, you are not able to unmute. Okay.
Anyway,
Okay.
we can talk.
You can type your
separately.
question. You can type your question in this one if it is required. Okay. Mr. Sanchit Garg, Siddharth, can you please, Mr. Sanchit Garg and Mr. Rahul Dal from DIPA.
Mr. Rahul, you can ask your question.
Mr. Rahul, you can please unmute yourself and ask question. We have authorized you.
Sanchit Garg, sir, you can unmute yourself if you are there.
Mr. Sanchit Garg, can you please unmute yourself and ask your question? Siddharth, check once again whether they are authorized.
Yes, sir, we have authorized them.
Colonel Sunil Kakkad, if you can unmute yourself, you can ask your question.
Sir, am I audible now?
Yes, you are.
Sir, in the Act at many places, you have mentioned that any such designated authority. Now, designation of that authority is being done by whom? Because when it comes at the district level and when you approach the authorities, they say we do not know the authority who's going to give you a permission or an answer to your query. So that designated authority, who's the final person to be approached for?
DOT, Department of Telecom.
At the district level, at what level, sir?
No, currently whatever is defined DM for the administrative disputes, district judge for the compensation related issues for damage to property, restoration of property. But apart from this, any central government, any authority to be designated by central government being represented through Department of Telecommunication. It will be done maybe in 2 months, maybe 2 years. It can change also. बिकॉज वो सेंट्रल गवर्नमेंट के पास पावर है डिफाइन करने का कि कौन सी अथॉरिटी इसको करेगी. हो सकता है कि हमारा जो LSA फील्ड उसको कर दें, किसी और को कर दें, बट इट विल डिपेंड ऑन द मिनिस्टर, सेक्रेटरी, द होल चेन ऑफ कमांड एट डिपार्टमेंट ऑफ टेलीकम्युनिकेशन.
Thank you, sir.
Thank you.
Ms. Neeti Mathur, you can unmute yourself and ask your question. Neeti Mathur.
Hello.
Please ask.
Yes.
You are audible.
Yes, thank you, sir, for providing us an opportunity to be a part of this webinar. Neeraj sir, the presentation was really helpful. I just have two queries. One, deemed approval clause, which was earlier been asked of the industry, is not mentioned in the Act, and I understand the rules will be coming. So I hope that will be covered in the rules that will be formed under the Act.
नहीं, देखिए ऐसा है कि डीम्ड अप्रूवल जो पहले था वो हम लोग रूल्स बना के कर रहे थे. अभी हम उसको एक्ट के बेसिस पे करेंगे. पहले कोई उसको एक्ट का बैकिंग नहीं था. तो व्हेन वी वर सेइंग 60 दिन, तो हम लोग स्टेट के पास जाते थे और उनको मनाते थे कि भाई इसको मान लीजिए, 60 दिन का है, यू अडॉप्ट इट. नाउ व्हेन वी से 60 days, देयर इज नो नीड टू आस्क देम टू अडॉप्ट इट बिकॉज़ इट बिकम्स ए सेंट्रल रूल, राइट?
Right, sir. But in case if the application gets, there is no revert on the application within the set timelines, then I hope the DOT will consider the clause of deemed approval under the rules to be formed.
Yes, yes, of course. So whatever is there in the current things, many of the things we were already doing through a softer method, through adoption of rules, framing of rules. Now
Yes,
the
sir.
rules which will be framed now, they will have the backing of the Act. That is the
Thank you,
difference.
sir. Thank you, sir. And just one more query, sir. Also, the regularization of the old towers, I hope that will also be covered under the rules that will be formed.
That can be covered, yes, or they can be covered.
So we'll be sharing a detailed submission on the ask from the industry and the inputs on the act, sir. However, this has come out really well and solved most of our issues. But we'll be sharing some more inputs with you on that, sir, on behalf
Okay.
of DIPA. Thank you, sir.
Thank you.
Thank you.
Mr. T.R. Dua, DG Deepam, can you please ask your question?
Quick one, sir. Thank you very much, Neeraj ji, for articulating. Only one quick query: the center versus the state relationship. As you rightly said, one of the important case, which is a Chhattisgarh matter, which the state has already given that the state has a right vis-a-vis. Now, with this act coming, I hope this issue will be resolved.
Yes, yes, this will be resolved. This will be
Thank you very much, sir. Thank you very much.
Now it is law of the land, Mr. Dua. Now it is law of the land. Everybody has to abide it.
Thank you.
Everybody is obliged to abide it. You know.
I will just add one thing, JS admin here, that this act is, I mean, it has yet to come into force. So things are being dealt in a legal kind of way, how it can help us. I mean, it can't be said right now that it will,
Yes.
I mean, because any act, it will be effective from a prospective date, not a retrospective. So it is already being, I mean, under consideration. I mean, how to go ahead with that Chhattisgarh case.
Mr.
Okay,
Dharmendra
understood.
Khajuria. Yeah, Mr.
Yeah.
Dharmendra Khajuria, can you please ask your question? Yeah.
Sure. Neeraj ji, we have been talking about some of the bigger states having issues relating to the rates. While I heard you saying that with this act coming, there will be some kind of transparency in terms of rate, because the last ROW rules, while the state was adopting it, but urban local bodies, they had their own bylaws. So ultimately, that backing, I hope this act, those rules will be backed by this act. And, like in Maharashtra's case, it, 1 crore kind of a rates are for 1 kilometer. Telecom infra cannot be, cannot be proliferated in those kind of rates.
Now, whatever rules will come and whatever is mentioned, the amount is mentioned. Now, there will be no need of any state or any municipality to have their own rules. We will not ask them to adopt. We will say they follow. As simple as that. Yeah.
Sure.
Mr. Vikram Malviya, can you please unmute your mic and ask your question? Mr. Vikram Malviya.
Yes. Am I audible?
Yes, you are.
Yes.
Yeah, there is a general problem with the facility provider that the old network is there, and sometimes the permission is not traceable or not available. So what is the provision for compensation or the procedure, if any, is specified in this act?
No, again, it is said that if you have paid compensation in the initial stage, so you will have to give the proof that you paid compensation or you restored the road. Then only for reshifting you can be given some compensation. You have to show some proof.
No, only if it's not the question of compensation. Even the shifting sometime is needed. They can cut the cable also if there is no permission as such, previous permission. So for taking out the cable and shifting it to the far end of the road, that is there any provision for that? Otherwise, they will cut it.
There is a provision. You will be paid compensation for shifting, but you will have to show that earlier you had taken the permission and you had paid for the compensation. If you had illegally laid the cable in the ground, then there will be no compensation because it is not agreed by the authority in the first place.
Okay.
Mr. Atul Kumar Jain, can you please open your mic and ask your question? Mr. Atul Kumar Jain. Mr. Rahul Dhal of DIPA, can you? Yeah, Mr. Atul Jain, yeah, you can ask your question. Yeah.
Thank you for giving me an opportunity. I am Atul Jain from Broadband India Forum. My query is related to the fact that this act, consequent to implementation of this act, when the rules will be framed, would there be still there be discretion in the hands of states and other authorities to decide the ROW charges,
No.
or would these be
No, no.
by the rules?
Answer is no. Answer is no.
So it would be uniform across the country, or it would be?
Yes. Whatever is defined in the rules, if it says maybe Arunachal Pradesh में थोड़े कम होंगे और दिल्ली में थोड़े ज़्यादा होंगे, whatever is defined in the rules, that will be applicable. If they say uniform across the country, it will be uniform across the country.
So would there be any consultation before the decision of the defining the rules?
Verma ji can better answer that if he is still here.
Yeah, yes, if required, we will have the consultation.
Okay, thank you.
Because still we are in the process of making the rules. So wherever we feel that it requires consultation of the industry, we will definitely do that.
Thank you, sir.
Rahul Dhal, Mr. Rahul Dhal from Deepa, you can open your mic and ask your question. Mr. Rahul Dhal, please open your mic and ask your question.
I think
Mr.
he's not able to.
Mr. R.R. Yadav, Mr. R.R. Yadav, you can unmute your mic and ask your question. Mr. R.R. Yadav, you can unmute your mic and ask your question.
Sir.
Yes, please ask. You are audible.
Good afternoon, sir. Regarding local authority rate, who will be the enforcement authority in case local authority will not follow this rule and TSP or agency want to lay the cable in that route? It is necessary for laying the route cable also. Who will be the enforcement authority in that case?
Department of Telecommunication.
Physical with the support of state police, or how?
No, that can be defined in the, that is not considered yet. That can be defined in the rules.
Okay, sir. Thank you, sir.
Mr. Praveen Sharma, you can open your mic and ask your question. Praveen ji, are you there? You can unmute your mic and ask your question. One last opportunity to Mr. Rahul Dhal. You can unmute your mic and ask your question. Otherwise, we are getting delayed, and I had to take all the questions related with ROW because Mr. Neeraj will not be available at the end of the webinar. Mr. Praveen Sharma and Mr. Rahul Dhal, if you are not able to unmute your mic, then probably we can move forward. Okay. So thank you, Mr. Neeraj. Thank you for a wonderful talk that you have given, and you have tried to clarify all the points. We know that our industry partners, TSPs and ISPs, are the major stakeholders of this Telecom Act, and they have a lot of concern related with ROW, and a wonderful provisions in the Act have been made. A lot of their problems would have been simplified, but then their concerns are related with which could be addressed in the rule. I would request on behalf of the participants that you please try to make a consultation with the industry people before you finalize the rules. This is a request to Joint Secretary Administration, Mr. Verma also, and to Mr. Neeraj Kumar also. Probably you are the two officers who would be framing the rules. ROW is a matter of utmost importance for these for these stakeholders. Thank you very much for your time, Mr. Neeraj. Thank you that you are from your outside trip also you managed to deliver this session. Thanks a lot.
Thank you.
So
Thank you.
Yeah, now it's the time for us to request Madam M. Revati, who is Joint Wireless Advisor and who has, we all know that who has been centrally placed for framing these act, the policies related with spectrum in this act. We would be directly listening to Madam M. Revati, Joint Wireless Advisor, on the provisions related to spectrum in this act. Over to you, Madam Revati.
Thank you, sir. And congratulations to NTIPRIT for timely arranging this webinar on the Telecommunications Act 2023. I have seen a lot of interest shown in this right-of-way related issues. Really, this act has covered a lot. Though I don't know much of it, probably we'll be bringing up the rules, detailing and addressing the questions. A lot of effort has gone into it. Now I request Siddharth, can you go to the next slide, please? Mr. Siddharth, can you, next slide? Yeah. As Mr. Verma told, the genesis of this act started with the spectrum policy. You are all aware that the spectrum policy subsequent to Supreme Court judgment, we have been doing on interim basis, like on ad hoc basis for the last 10 years. When finally the policy was finalized, was going to be finalized, then Honorable Minister told, let us make a Spectrum Act. It all started with Spectrum Act. Then we started doing the other acts, they're old. Then finally, lot of things modified, merged, and Telecommunication Act has come. And we are very happy that it got a right place. The spectrum assignment methodology got its right place in the Telecommunication Act. I'll just, we have been assigning the spectrum, we have been issuing the wireless operating licenses, but we have been issuing through the 1885 Act because there is a provision under Section 4 to issue the licenses to establish telegraph stations using Hertzian waves. That is nothing but spectrum. Of course, spectrum was not explicitly mentioned in that act, but there were provisions. And we have repealed one more act, that is 1933, that is for possession of the wireless equipment. Now come to this act, there are basically 11 chapters, there are 62 clauses and 3 schedules. Schedule 1 deals with assignment of spectrum through administrative process, and Schedule 2 civil penalties for breach of some certain terms and conditions, and Schedule 3 civil penalties for certain contraventions. My focus will be on majority of the clauses related to spectrum and on the Schedule 1. Next slide, please. Next. See, establishment and operation of telecommunication network using spectrum. That is predominantly covered under clauses 3 and 6. There are so many subclauses in clause 3. And the clause 3 gives authorization to establish, operate, maintain, or expand telecommunication networks subject to terms and conditions as prescribed. We are coming with the rules. Already the rules have been in the draft stage. We are refining them. This clause 3 of the chapter 2 talks about authorization. Here we are replacing that license with the word authorization. Authorization to establish telecommunication network, authorization to provide telecommunication services, and authorization to possess radio equipment. Then there are certain exemptions from this requirement in the public interest. That again, clause 3, subclause 3 of the subclause 3 speaks about it. This clause we invoke when we are doing, especially certain types of broadcasting receivers. They are not covered under any license or authorization. We invoke this clause and we use this provision. Similarly, some delicensed bands, some equipments operate in the license exempt frequency bands. For that, you don't need any authorization from the government of India except equipment type approval and all. Can I see the PPT? Yeah. So that is through this clause, that provision. Any exemption granted under will continue. That is the continuity of the services. So far, we have been issuing the licenses and permissions with 1885 and 1933, and we have given some exemptions under those acts. They will continue. That is the continuity. The clause 3 takes care of that. Subclass 4 of clause 3 takes care of that. Then there is another important clause, like migration from the old system, old licenses and permissions to new authorizations, new design. That is, if any instrument issued under the earlier acts, which is having a specified validity date, so that continue to valid till that time. If there is no specific validity date mentioned there, then it will continue under the same terms and conditions for 5 years. That is a clause 6. It is a continuity of the services. continuity of the permissions, continuity of the licenses. This is without disruption to the existing services. Next slide, please. Then another important, that is clause 4. It has clearly defined about the spectrum assignment methodology, and National Frequency Allocation Plan has been given the legal backing through this act. What is this NFAP, National Frequency Allocation Plan? Those who are involved in the spectrum management industry, they are aware of it. That flows from the radio regulations of the International Telecommunication Union. That radio regulation is a policy document. It's a regulatory document. It specifies what are the frequency bands, what type of services can be provided in that frequency bands. This radio regulation is a treaty document which is signed by Government of India. So this RR, that is called, we call it as RR Red Book. It is reviewed every 4 years through World Radio Communication Conference. And around 4,000 people participate in this, spectrum and regulatory experts, they revise it. This radio regulations, subsequent to that radio regulations, National Frequency Allocation Plan, on the basis of the radio regulations, taking into account your national requirements, this National Frequency Allocation Plan also revised every 4 years. Current NFAP is, shortly we call it as NFAP 2022. Now we started revising it with a public consultation and all. Probably we'll be coming out with NFAP 2024, which gives a guiding document about spectrum management, spectrum usages in India. Even the other countries refer our NFAP. So here, the first time NFAP has taken up, it's a place in the Act. Central government is the owner of the spectrum. It shall assign the spectrum in accordance with the Act and may notify a NFAP from time to time. We will be revising it. Then subclass 2 of the 4 says, whoever using spectrum, they need an assignment. That is an instrument. You are different types of instruments here. One I spoke about authorization. Here it is a spectrum assignment, another instrument from the central government to use the spectrum. Another important point is predominantly all the spectrum will be assigned through auction, except for that which is given in the first schedule of the where it is administrative process. Even JSCA also spoke about first schedule. We'll come to that later. The central government first schedule. Why some assignments are going into first schedule and the administrative process? Because they meet these 3 conditions. First is in order to serve public interest. Public interest like Prasar Bharati, All India Radio, Doordarshan, something like that. In order to perform government functions, security, defense, forest, state governments, government functions. Next, in cases where auction of spectrum is not the preferred mode of assignment due to technical or economic reason. I will quote one example of technical reasons. It is not the preferred mode because in the satellite case, the same spectrum is used by multiple users in the same location. Technically, it is not possible, it is not feasible to auction the spectrum. Those type of cases also you will put in the administrative. Economic reasons. Certain portion of the spectrum you are auctioning it. Some other portion of the spectrum is mandated to provide the services. You cannot auction that against spectrum. And economical reasons. Certain times the spectrum may be possible to auction, but the amount you spent to conduct the auction and to get the revenue generated will be very, very less compared to the amount you are spending on the conducting it auction. So these type of, whichever is meeting these conditions, they will be going into the schedule 1. And this schedule 1 is not hard coded. That schedule 1 can be amended, not through the act. It can be amended through a GSR notification with the approval of Honorable MOC. Then with the law, it will be GSR, it will be published, and GSR has to be laid before the House of Parliament. Next, please. Next slide, Siddharth. Yeah. Then further clauses like license exempt, that is delicensing we do. That is subclass 6 speaks about this, exempt from the requirement of spectrum assignment in public interest. Like Wi-Fi, RFID and all, we are periodically delicensing certain spectrum for certain applications. So that we draw the power. This is the enabling provision. Next provision is continuity of the services. That is, whatever you have already exemptions granted, de-licenses, things under the earlier act will continue. Then the other last two bullet points are important. One is, so far we have been assigning the spectrum through administrative process. Prior to the appoint date, that appoint date will be notified, shall continue till the validity of such an assignment. If there is no validity mentioned, it will be there for 5 years with the same terms and conditions. In case of assignment, spectrum assignment through auction, it will be on the same terms and conditions on which it had been assigned. Next slide, please. And you must have heard of this reforming, harmonization, flexible use of the spectrum. We have made already these guidelines, reforming of spectrum, harmonization, spectrum sharing and trading. They are in force. Now they have been brought in the legal backing. So more efficient use of spectrum, reform, harmonize under section 4, subject to such terms and conditions as may be prescribed. So those rules are already, draft rules are in place. We are working on them. I think probably within 2-3 months, we'll be able to publish them. Next is may enable utilization of the spectrum in a, go back to the next slide. So there is another very important provision has been made in this act, that is the flexible use of the spectrum. So far we have permitted technology neutral manner, that is technology agnostic, like IMT spectrum, you can use any technology, GSM, CDMA, LTE, WLTE, whatever it is, so far as it is the IMT. Now it is a future case. This act will be there for maybe another 100 years. We are facilitating that flexible use of the spectrum, like you are talking now. The IMT spectrum may be using for MSS, mobile satellite service, or IMT spectrum or satellite spectrum, MSS or FSS will be used for some other provision of the services. That provision has been made in this act, and through the rules we'll be making, as once that regulatory conditions are available with us, probably will be coming out the rules on that. This is a very forward-looking provision made in this act. Next, please. Optimum utilization of the spectrum. So far, we don't have the rules, but we were talking a lot about this optimum utilization of the available spectrum. And there are two provisions has been made. One is, if the spectrum is assigned to some primary entity, and if secondary entity can come into it without causing interference to primary entity, there is a enabling provision. So DOT may come up with the proper rules, how it will be. Probably they will go on consultation to come up with the rules on that. This is a very forward-looking provision to ensure optimum and efficient utilization of the spectrum. Another last clause is the reasonable, suppose somebody, especially some government entities or any entity taken holding the spectrum, they are not utilizing it. They should be given the reasonable opportunity, and if the spectrum remained unutilized for insufficient reasons, central government can take back that spectrum or can further put certain terms and conditions on that spectrum utilization. There is an enabling provision, and the rules are being framed to work on it. Next, please. Next slide, please. These are all we are talking about, how to establish the wireless network, how to assign the spectrum. Then I come to the third point, because that Wireless Telegraphy Act 1933 talks about position of radio equipment. That has been repealed now. So there is a provision here, position of the radio equipment. So for position of the radio equipment, we are drawing the power from the clauses 3 and 6. Clause 3 is authorization to post the radio equipment subject to terms and conditions. That is a class, subclass 1 of it falls in that category. Then exemption from this requirement, I already told, license exempt devices, license exempt frequencies used by the devices, they are also exempted from this requirement. That has been captured, and any exemptions granted there will continue, and any such like we issue some equipment type approval, something based on these rules, they continue to valid. If a specific time is mentioned, they will be valid for that time period. If there is no date is mentioned, they will be valid for 5 years. It is a common clause across these authorizations and assignments. Next slide, please. Apart from this, there are establishment of monitoring and enforcement mechanism has also been given a legal backing in this. Monitoring and enforcement mechanism to ensure spectrum utilization and enable interference-free use of the assigned spectrum. Also, there are provisions for sharing, trading, leasing, and surrender of assigned spectrum. There are already guidelines, but now they have been brought into the Act. Detailed rules will be framed on this. Similarly, there is a clause regarding that no person shall be entitled to the refund of any fees or charge if the spectrum assignment is suspended, curtailed, or revoked or varied. Next slide, please. So, spectrum regulatory sandbox. It's a much it's a very good idea. We have already made guidelines for the spectrum regulatory sandbox, but now that legal backing has come, it is a little different from the experimental licenses what we issue. Experimental and trial licenses issued by the WPC and WMO. The spectrum regulatory sandbox is you create a sandboxes like that. There, even the assigned spectrum, suppose let us say 3.3 gigahertz spectrum is already assigned, we don't have any 3 spectrum. But if R&D or any innovator wanted to test their product in the 3.3 gigahertz, they can go to this regulatory sandbox and they can test there. They can establish small network, they can test there. So they need not come to WPC every time to get the spectrum. Only that regulatory sandbox entity owner will be registered with the DOT and he has been given some authorization. That owner will ensure that these testing entities will not cause interference to the authorized users. So people can do R&D innovators, they can go and do test in the assigned bands or non-assigned bands, they can do experiments and all. It's a very forward-looking thing, and in fact, we are making this software provisions in the Saral Sanchar portal also. The class 27 is for facilitating innovation and technology. Next slide, please. Apart from the spectrum assignment, we also issue the certificate of proficiency. Certificate of proficiency to the skilled personnel who operate the radio equipment on board the aircraft and on board the ship for radio navigation and safety purposes. These clauses covers that we grant a certificate of proficiency and license. We call it as RTR for aeronautical for aircrafts, and the GMDSS, GOC, General Operator Certificate, we call for ships. So class 46 provides for that, both types of this. And class 47 deals with amateur stations. Amateur is a hobby to promote technical interest and R&D in the students especially. This amateur worldwide, there are certain frequency bands identified as RR and NFAP. People can do experiments on that. We conduct the exam and all for students, we encourage, so they can, the guidelines, rules are very simple in this. So there is a provision for that through class 47. Similarly, finally, you must have heard of lot of booster menace. TSPs are facing problem, even the public are facing the problem, boosters and jammers. How to control them? So there is a provision which specific provision. No person shall possess or use any equipment that blocks telecommunication unless permitted by the central government or any authority authorized for specific purpose by the central government. See, these jammers are not permitted to be installed by anyone except Cabinet Secretariat security for the jails and certain places, VIP movement and all, they give a permission. And unfortunately, these jammers, they jam everything. They don't confine to that jail limitations also. So those, to address those issues, this class 48 is there and probably will be coming with the rules on it. Next slide, please. Of course, these are the general clauses applicable to everyone, and they are applicable to even the spectrum assignments and authorization for establishing wireless networks. They confers the central government to make the rules by notification subject to conditions, whatever it is. And particularly wherever they have mentioned a prescribed, they brought under clause 56(2) for what are the clauses, subclauses, you need to make the rules. Next, please. Next slide. Power to amend the schedules, which is very important for us. because we have codified certain spectrum assignments as a Schedule 1. We draw the power to amend that schedule through clause 57. So confers the powers on the central government to amend the schedules of the Act by notification, that is through GSR. Then clause 57, subclause 2. Any amendment made under this subsection shall have effect as if it enacted as a part of the Act and shall come into force on the date of the notification, unless we say otherwise. So periodically, the spectrum assignment categories will be going into that Schedule 1 and coming out of the Schedule 1 as the technology goes and depending on the situation changes. That is the provision. It's a very, very good provision. It is not hard codified. Go to the next slide, please. Repeal and savings. So the repeal of this, whatever the any action taken, including grant of license, registration or assignment, any order under the repealed legislation shall be deemed to have been done or taken under the proposed legislation. And clause 61 says, provides for existing rules to continue. We have certain rules, there are existing rules to continue. It states that all rules, orders made or purported to have been made under the repealed acts shall continue until they are superseded by the rules under the proposed legislation. We are with the not proposed legislation, under the new act actually. This has to be changed with the new act. With the new act, we are making the rules. It might take maybe 2 to 3 months. Till that time, whatever the rules and orders early made and the earlier act will continue. Next, please. That's it. That's all my presentation on the spectrum today. Ready for take any questions.
So first we see from hands raised, Mr. Praveen Sharma has raised his hand. Siddharth, can you please allow him? Yeah, Mr. Praveen Sharma, you can open your mic, ask your question to Ms. Revati. Yeah.
Yeah, am I audible?
Yes, you are.
Very loud.
Yeah. Thank you so much. Actually, my Teams was not working. It was on web, so therefore I was not able to. So my first question is relating to the implementation of the Act. Whether the appointed dates would be different for different parts of the Act, or whether it would be the same date of implementation, that is appointed date. How it's going to get implemented? What is the time period? That is the first question. It is to JS Admin Saab, which I could not ask earlier. The second question is to Madam Revati. The section 7.1, which provides for secondary assignment. In case of auction spectrum, can you, because in auction you have sold the spectrum for 20 years to the assignee, whether you will still exercise those powers to do the secondary assignment in the case of auction spectrum? That is one question. Second question is that section 8.2, where you are providing sharing, trading, leasing and surrender of assigned spectrum. So that is the right place where the spectrum should come. Lastly, the second question, ma'am, to you is regarding the administrative assignment of the spectrum. The administrative assignment was a no-no since 2012, strictly speaking. And now this act opens up the new vistas, and rightly so. Whether you have filed anything in Supreme Court also to take clarification from Supreme Court on this? That's the question. Thank you so much.
Okay,
so may I request JST to first answer the first question?
The issue regarding the implementation timeline, yes, I can share that we are in an advanced stage, and we are working, to implement it at the earliest possible. Timeline as such, we cannot give right now, but yes, we will be implementing it at the earliest. And regarding whether it is section wise or part wise, this we will, when we are in a stage of implementation, then we can take a call.
Now I request Madam Revati to answer the other two questions of Mr. Sharma.
Thank you, sir. Very nice questions. I'll come to the first question. That is the secondary assignment in the auction spectrum. That's 7.1. This is the enabling provision. While drafting it also, these questions have been raised. Suppose you are auctioned the spectrum for 20 years, how you are going to give the primary, secondary assignment? So far we have not made any rules because there are no guidelines on this. This is the futuristic sort of a thing. if government, in my view, it is my personal view, the government is going to do any of such rules as may be prescribed, probably it will go for a wider consultation through TROI and all. So it is immediately thinking in for auction spectrum probably very, very premature. We can do that for any of the other spectrum where it is used for only short period of time and it is vacant for longer period. Those type of applications, what I see immediate usage. Anyhow, that will go wider consultation before it finalized into a form of a rule. The second question, you said the central government may permit sharing, trading, leasing, and terms and conditions. It should have come in the spectrum. Yeah, I do agree. It is coming with the establishment of monitoring and enforcement mechanism. You should have gone with the other places you told. Okay.
Yeah.
What is
actually it's a very welcome move, ma'am, for all these service providers, because there are only 4 spectrum based players. If you allow sharing and other things, at least then there may be more spectrum based players which may come up, sir.
Exactly. But you told one more point.
That was regarding whether you have filed any Supreme Court
administrative assignment. I just come to that. So for the last 2000, since 2012 onwards, there was no permanent policy, but we have been, whatever we have included in the Schedule 1 of the Act, we have been assigning administratively only. Whatever currently being assigned administratively only have been brought into Schedule 1. We have been assigning administratively. And no one said that you have to auction all these type of things. No one said, even the file moved and no one said, but decision was not made. I limit my answer to this point because I'm not privy to other decisions where did we file in the Supreme Court and also.
Thank you, sir and ma'am, for your responses. Thank you so much, Sinha sir.
Thank you, Mr. Praveen. Now I see a hand raised from Mr. Vikram Tewatia. You are authorized to open your mic. Please unmute your mic and ask your question, Mr. Vikram Tewatia. Mr. Vikram, please unmute your mic and ask your question. Mr. Sanchit Garg, you can unmute your mic and ask your question. Mr. Sanchit Garg.
Sir, am I audible?
Yes, you are.
Yes, ma'am. Good afternoon, ma'am. Ma'am, there is one question that in the June 2022 guidelines, there was a need for captive network spectrum allocations that whenever any enterprises wants to establish captive network, there were 3 provisions for utilization of the spectrum. One was through administrative spectrum allocation, second was through network slicing, and third was through TSPs. So, ma'am, in the starting, there was a very high utility for the captive networks, but since TSPs have not been providing a spectrum to the captive enterprises, like we have seen in the IMCs also, there was one major question that we are not having availability of the spectrum with us, because network slicing is not possible as of now in India. Only Jio will be providing in a later stage because it will be requiring 5G core. So, ma'am, how the captive network enterprises will be able to grow in India as we have been seeing in other countries? Thank you, ma'am.
See, I could see you are talking about CNPL, captive non-public networks.
Yes, ma'am.
So there are already, I think DOT has come up with 3 provisions, how they can take the spectrum or they can take the service from the TSP. There was a last mechanism, like the direct assignment of the spectrum from the DOT. So there is a policy decision. I think it's a pending policy decision is pending, or it is being deliberated within the DOT and all. The schedule doesn't cover that. As on date, schedule doesn't cover that because there is no decision on it, what to do and all. It is not even in the interim assignments. Whenever the decision is taken by the DOT or government, whether to do directly administratively or through auction or depend IMT bands, non-IMT bands, probably it will take a place either in the auction mode or in the schedule 1. I hope I answered your question, Mr.
Yes,
Garg.
ma'am.
Mr. R.R. Yadav, can you please open your mic, unmute your mic and ask your question? Mr. R.R. Yadav, yeah.
Yes, sir. Namaskar, sir. I am audible, sir.
Yes, you are.
Very clear.
My two questions, sir. One little question that Wi-Fi band will still be continue free. Second, what about the regulatory sandboxes? Will it be geographically located locations or it will be doorstep for the innovators?
See, good questions. The first question is that Wi-Fi will continue. I have already told so many times there are a provision continuity of the services. If you have exempted certain frequencies for D license with limited technical parameters under earlier acts, they will continue to do. They will be there. So that legal continuity has been brought in the act with certain provisions. They are there in my presentation. I think they will be sharing. You can check that. Then come to the regulatory sandbox. That's a very good question. Regulatory sandbox, almost the committee headed by Mr. Karandikar, Professor Karandikar, with all the stakeholders, they have recommended in 2021 or 22 itself about the spectrum regulatory sandbox, which has been approved by the DCC and all. The order has to be issued with the approval of Honorable MOC. Now that has been brought into the Act. When you come to regulatory sandbox, there are two types of cases. If unassigned band is being tested, it is not assigned to anyone. You can test in the IIT premises like that. Even in the city like Delhi, you can do it. If you are testing the assigned bands, suppose I have given 3.3 gigahertz to here Reliance Jio, and somebody is testing in the IIT Delhi, it is not possible. So the guidelines have specified if it is assigned band, it should be away. It should not be in the what you call main urban cities and all, like in the deserts areas or in the forest areas. If it is in the unassigned band, yes, all the IITs or even private PSP who is having a big campus, we have defined the areas, how much area should be there for VHF, HF, UHF for satellites and all. And the another thing, what you told, whether it is open the door for innovators, yes, DOT will not be charging huge amounts. They need not come to DOT WPC anytime. The facility provider, once they give, facility provider only will be handling them. So it's a very easy, like, no, ease of doing business. And people can go with the product there and they test responsible people and then come out.
Okay, ma'am. But supplementary questions arises about that. You know that R&D cost itself is a very huge, and if an innovator visit to the designated location for a testing purpose or even for the innovation purpose for say 10 20 days or even more than a year, sometimes takes to evolve a product, it will be very cost innovation, and that may not be viable in some cases also. So it should be liberal whenever you make a policy. Innovation stages should be made, that innovation stages, testing stages, and then the adaptation stages should be there. Thank you, ma'am.
Yeah, thank you.
Mr. Fateh Singh, can you please open your mic and ask your question? Unmute your mic, Mr. Fateh Singh.
Yes, sir. I am audible.
Yes, you are.
Yes, sir. I am Fateh Singh, Director of Technology from Jaipur. Actually, in earlier Telegraph Act, it was very clearly mentioned that government is empowered to establish and maintain telecom services. But in new act, nothing is there about the same. Why? Government is always required to maintain telecom services, but here nothing is mentioned in this regard.
Yeah. Okay. So what I am able to get is that in section 3, under the heading authorization, it is written that any person intending to provide telecommunication services shall obtain an authorization from the central government on subject to terms, condition, including fee charges. Is it okay? Or anything else you are talking of?
No, it is okay, but it is other than the telecommunication department. It is other than the state PSU, state government, but it is not mentioned of the government itself, the government of India. See, today BSNL will MTL is there. Tomorrow, suppose we are privatized, even we are also maintaining other telecom services. like CMS system or other many services may likely to come in the future. So such cases it is required to maintain also, we are also maintaining and operating and establishing the telecom services should be there.
No, yeah, if you permit, can I just
Yeah,
come?
I'm not able to understand the.
There is a, yeah, his observation is right. There is a phenomenal difference. When the 1885, you say central government, they will establish the network. They have also the power to establish and provide the services. In this act, because central government is no more is providing any services, the idea is authorize the people to provide the services. Now, even today, we are authorizing BSNL to provide the services. I don't think anywhere central government, probably it has been deliberated and accordingly it has been drafted like this. Some more information, I think DDG asked Mr. Singhal was closely involved. He will be able to share. My idea was that even during discussions, it was like central government authorize someone who will, central government itself will not provide the services. This telecommunication.
Central government is establishing and maintaining today itself telecom services in various ways. As per the telegraph, for this rule, the Telegraph Act of 2023, we are maintaining and operating many telecom services, which is in the purview of this telecom services, telecom equipment, and other what many terms are there. So it is come in this ambit of this act. So it should be there.
Can you name a few services? I mean, I am also not really able to appreciate what service government
is providing.
See, sir, today we are maintaining central monitoring system. Also, other telecom services like this Telecom, on other also this more.
No, you are doing. I think whatever we are doing is we are not providing. See, if you are 4 operators, devotee is not as a central government providing any services as on date. Yes, you are maintaining law, legal interception, or some associated activities, not the services. So to provide the services, you need authorization on behalf of government. PSU is doing it. That's my understanding. Anyhow, I think Mr. Singhal can.
Tomorrow PSU may not be there. So if case DOT itself to operate some services, it should be there. My request is only that.
See, once you are giving any right to provide services to the third parties, you always have that inherent right to provide the services if the conditions so require. So the earlier act, section 4 was that government can provide services, and first proviso said that it can license other people. Now here section 3 is saying that they can give authorization to other third parties, but they will always have that inherent power. The person who gives the thing to other person will always have the power to do that thing. That's a legal maximum. So it will be like that.
Mr. KV Thomas, can you please ask your question? Mr. KV Thomas, you are already on mute. Please ask your question.
Good afternoon, sir. Thank you so much for giving the chance. So it's regarding service license and spectrum allocation. There is a license called CMRTS, which is normally taken by the central government agencies and state government, like state police department, fire department, then all every metro railway, rails and airport, port. They use this CMRTS service, not a service, captive use of CMRTS license for their captive use. But that license has two stages. One is that the service license is on them, which is actually for a revenue generated activity. Service license supposed to be. Here it is a pure captive use where there is no third party involvement and no revenue generated, but there is a service license imposed on them and they are forced to maintain it also. And in addition to that, getting a service license, then getting the frequency allocated. So can we simplify this to only the frequency allocation to as the new act also clearly says for allocation to the government agencies and PSUs. So these are mainly by the PSUs and government agencies only. So my request is that can we do away with the service license from the CMRTS and allocation is possible?
Yeah. Your question is complete, I think. I'll answer?
Yeah, please, madam.
Yeah, this is already covered in your ports, mines, safety and all. And in the rule, it has been taken care. Because now that authorization, there is no question of license now. It is authorization come assignment. So a spectrum is assigned because they are port, mine, rails and all. There are the holders of CMRTS and authorization under section 3. It is combined into one instrument as per this act now. It has been simplified. It has been simplified.
So that says that the CMRTS license, service license will not be there anymore.
No, there is no question of service license, first of all. That we try to, that's what, no, so many 100 types of, you must have heard a introductory speech by DG NTIPRIT. 100 types of license have been removed into simple authorization. So that authorization come assignment will come on instrument to use that, because it is not a commercial activity at all. Wherever a commercial activity, there are some other, like somebody is providing a telecom services to public, general public, you need to come with some other attachments to it. Here it is not the case. Similarly, walkie-talkie, something like that. So probably it will be addressed in the rules.
Thank you, madam. Thank you very much. Thank you.
Thank you, Revati ma'am, for a wonderful presentation and making the provisions of the act related with the spectrum so simplified for understanding of our audience, and it has generated a lot of interest and traction. Thank you very much for a interesting presentation. And ma'am, I will request, and I'll also request to JS Telecom that please be with us, because there are certain questions in the chat box also, which we would be taking at the end of the session. Now we are only remaining with one last session, that is provisions related with security. And may I request PK Singh sir to please open his video and mic and load the presentation to place. Over to you.
Thank you, sir. Thank you. Thank you,
ma'am. Yeah. Siddharth, can you please take him on board?
Yes, sir.
PK Singh sir.
Sir.
Yeah, just am I audible, Siddharth?
Yes, yes, you are audible, sir.
Thank you.
But your video we are not able to see, PK Singh sir.
Yeah, just give me a second.
Sure, sir. Sure, sir.
Yeah, is it visible now?
Yes, sir. It's visible, sir.
Yeah, and we are able to see the movement of the slides also.
Not yet, sir. I think it is not in slideshow mode yet.
Please go to slide mode, sir.
Ah, okay.
Sir, kindly share your entire screen while sharing.
Yeah, that is what I am about to do.
Yes, sir.
Entire screen. किसको?
इस पे माउस पॉइंटर ऊपर ये होगा आपसे.
Yes, sir. Screen is visible. Now share your presentation.
Now it is visible.
Yes, sir. Now it is in slideshow mode.
Okay. And now the slides are also changing,
yes,
getting
sir,
changed.
Slides are also moving.
Yeah.
Sir, just
Thank you.
Hide this, sir. This one notification is there in the bottom. Yes,
yeah.
Sir.
Thank you.
Thank you, sir.
Can
you start, sir.
Yeah. Okay. So thank you, NTI, for giving me this opportunity of sharing the views about the security provisions in the Telecom Act 2023. And very rightly organized at the most opportune time. There is a lot of craze and a lot of information is being sought by all the stakeholders about the various provisions of the Telecommunication Act, and towards this purpose, the organized the organization of this workshop is a very well planned activity by NTI. Kudos and congrats and best wishes to NTI for continuing with this.
Thank you, sir.
Coming to the security provisions, coming to the executive provisions for the security in the Telecommunication Act, this Telecommunication Act has a lot of differences from the its precursor or the act which it has replaced, the Indian Telegraph Act of 1885. In the 1885 Act, we primarily had the provisions for the security in the section 5.2, but here we have a lot of other provisions included to keep up with the pace of the technology evolutions and technology development, as well as attempt has been made to provide a lot of flexibility, versatility, and a lot of user options to the government agencies to keep up pace with the technical developments and the needs and the necessities which have been felt over a period of time, which were earlier not available in the 1885 Telegraph Act. So all those things have been taken into consideration. Like this act doesn't limit itself only to the provisions of interceptions. It has provisions for notifying the standards and a conformity assessment for matters relating to cybersecurity for telecom services and telecommunication networks. It has provisions which will facilitate the government in notifying standards for encryption and data processing. This provision for data processing is very, very important. Earlier, we did not have much appropriate provisions in the Act, in the Indian Telegraph Act, but here it has been categorically included as one of the important security provisions. We'll be shortly seeing what those provisions are. It also has provisions for the protection of users. It also has provisions wherein one very important criteria has been indicated that to whomsoever the service is required to be provided by the telecom service providers or by the authorized entities, the verifiable biometric verifiable identity is has been made mandatory. The rules and procedures governing those are in the process of being formed, and also one very important thing which has been included is the grievance redressal, a mechanism which is required to be made available for the users and for the various other stakeholders also. So this is executive summary of the security provisions. Now coming to the details of the security provisions, those security provisions are basically covered in Chapter 4, and these security provisions are primarily concentrated in Chapter 4, but in other parts of the Indian Telecommunication Act 2023, they are interspersed with other provisions also. So we'll be covering all those things. The first and the very important security provision which has been included in this act is covered under Section 19, which basically says and which gives the power to the government of India to notify the standards and conformity assessment measures for telecommunication equipments, telecommunication identifiers, and telecommunication networks. One important thing which has been added here is the telecommunication identifiers. A lot of standardizing bodies, they have defined many telecommunication identifiers, like MS-ISDN is one telecom identifier, IMSI is another identifier, IMEI is another identifier. Then there are other identifiers also facilitating the technological developments pertaining to the voice over IP for the M2M communication. So all those telecommunication identifiers are going to be made use of in the telecom network, and government has given the authority to lay down the standards and the conformity assessment measures to manage these telecom identifiers, apart from the telecom equipment, the telecom network, and the telecom services. And telecom services are going to be regulated
in consonance with the provisions made by the Telecom Regulatory Authority of India from time to time. So due care to the role of TRAI has also been made in the security provisions. Then another area where the standards and conformity assessment measures can be made are related with the manufacture, import, distribution, and sale of telecom equipment. A lot of equipment in the country is getting manufactured, but it is also a fact that a lot of equipment gets imported into the country, and it has been felt that there is a need of doing a control, exercise control over the import of the telecom equipment so as to ensure the telecom network security and the cyber security of the telecom network itself and the telecom services. Hence, there is a need and requirement felt for laying down the standards and conformity assessment measures for manufacture, import, and distributions. Then another important thing which has been added is the cyber security standards and conformity assessment measures have been included as part of a subsection under section 19. Plus, very important feature which has been included is laying down the standards and conformity assessment measure for encryption and data processing in the telecom. A lot of data gets generated. So how are we going to manage that data? How are we going to analyze the data? How are we going to share that data? That also has been included in the Telecom Act 2023 under the provisions available in Chapter 4. So the Section 19 is basically a window to all the relevant security provisions available in the Chapter 4, and we'll shortly see how my statement is going to get vindicated when I say that the Section 19 is the window to security provisions in the in the Telecom Act 2023. Now, moving to the Section 20, which basically gives the provisions for what is required to be done in case of a public emergency or for the public safety. So there are 4 provisions available here. The subsection 1 of section 20 says that the government or a state government can take a temporary possession of any telecom service or telecom network from an authorized entity, and also the appropriate mechanisms can be provided to ensure that the message of a user or group of users authorized for response and recovery during public emergency are routed on priority. So there is a provision for taking temporary possession in case of a public emergency, including disaster management or in the interest of public safety. And also in case of a public emergency, including disaster management, the disaster relief handlers or the disaster relief agencies, their messages, their communications can be routed on priority, playing a very important role in the disaster mitigation and taking relief from the disasters. And the subsection 2 of section 20 is basically related with the lawful interception and other related matters which were already existing in the section 5 subsection 2 of Indian Telegraph Act. So it basically says that the message and the message has been defined to comprise of any type of communication. It could be a text, it could be video, it could be multimedia communication by any means. So message basically covers all type of communications which are currently possible. So if those messages or class of messages to or from any person or class of persons to or from any telecom equipment or class of telecom equipment or relating to any particular subject are brought for transmission or transmitted or received by any telecom service or telecom network, either it shall not be transmitted, the first thing. The second is it shall be intercepted or detained. And third is shall be disclosed in intelligible format to the officer mentioned in such order. So there is a dicto copy from 1885 Act. Just the additional things which have been made available here are shall be disclosed in intelligible format, and this is basically to the best technical capabilities available in the network. If the technical capabilities are existing in the network, it will be made available or it will be disclosed in the intelligible format. If the technical capabilities are not there, the technology doesn't support or the technology prevents the disclosure of a message in intelligible format, then that shall be the case. Then there is the section B, which relates with the provisions available for the suspension of the service. The condition precedent are what has been indicated in the main clause. Subject to those conditions, the service, telecom service, or from to any person, class of persons, etc., it can be suspended, and there are conditions indicated in subsection 4, which says that the suspension or the interception or the taking over will be not indefinite. There has to be some definite period, and there has to be certain conditions included for laying down under what manner and what circumstances such powers are going to be exercised. Now, going to the next provision related with the security is the section 21, which comprises the provisions related with the national security. In case of national security or friendly relations with foreign states, or in the event of war, the central government, if it is satisfied and it is necessary or expedient to do so, by notification will take certain measures which are necessary to handle the circumstances, and will issue directions in respect of use of telecom equipment, use of telecom services and telecom network and identifiers. It will also prescribe standards applicable to manufacture, import and distributions. It will also define the standards to be adopted by authorized entities or assignees. There could be a different set of standards for peacetime operations. There could be different standards for warlike situations, and there could be different standards for the situation where the actual warfare has begun. So the government has been given the mandate of laying down the appropriate measures by way of incorporating appropriate mechanisms, appropriate clauses by way of section 21 to take care of the national security requirements. Going to the next provision, which allows the central government by way of rules to take care of measures aimed towards the protection of telecommunication networks and telecommunication services. Now, in this, the development which has basically happened over the past few years, and the need and the necessities which have been felt primarily relate to how the telecom data which gets generated, how that telecom data is going to be made use of for doing a lot of things which are beneficial to the customers, which are beneficial for the network security, which are beneficial for the cyber security of the telecom network. So all those provisions are basically defined and covered under the section 22, subsection 1, 2, 3, and 4. The subsection 2 of section 22 relates with the measures which may include collection, analysis and dissemination of traffic data that is generated, transmitted, received or stored in the telecom networks. So this is, I'll say, a very important and very strong provision which has been made available, and you all are aware that a lot of data gets generated, and when I am saying a lot of data gets generated, we and the government have limited itself to the traffic data, and they have defined what exactly is meant by traffic data. the content is not going to be touched, the content is not going to be collected, it is not going to be analyzed, it is not going to be disseminated. It is only the traffic data, and the traffic data for this purpose has been defined as the data generated, transmitted, received, or stored in telecom networks, including data relating to the type, routing, duration, or time of a telecommunication. So we have consciously kept ourselves away from the content. We are not going to have or make any provision which is going to have an impact on the privacy of the communication. So apart from the content, all the headers, metadata, traffic data, etc., by whatever name the data is known, that is going to be made use of for analysis, for dissemination, and for collection. Plus, another very important provision which has been included is that the government will notify in official gazette and declare any telecom network or part thereof as critical telecom infrastructure, a disruption of which will or may have a debilitating impact on national security, economy, public health, or safety. Certain safeguards are going to be prescribed, certain security measures, and those security measures will be different from the normal telecom network. And if a part of the telecom network or a particular network element has been declared as part of a critical telecom infrastructure, there are going to be special provisions for the network security and for the cyber security, for the health and for management and for monitoring of those critical telecom infrastructure part of the network elements. So that is basically what is covered under the section 22. Now the section 23 relates with the other security provisions, which basically says that if it is appearing necessary or expedient so to do in the public interest, the central government may direct any authorized entity to transmit in its telecom service or telecom network specific messages in such manner as may be specified. So these specific messages could be used in times of if a disaster is about to occur, so the public can be made aware of the impending disaster, and they can be moved and they can be asked to move to safer and secure places. The specific messages can also be made use for creating an awareness among the telecom users so that they do not fall prey to the cyber fraud and any cyber crime. Plus, there are other use cases also wherein this particular provision available in section 23 can be made use of. Then continuing with the facilitating provisions of the Telecom Act, the section 27 also says that creation of one or more regulatory sandboxes has been included. Now, these regulatory sandboxes could be for a variety of purposes. The term regulatory sandbox has been defined, and these regulatory sandboxes could be used for live testing environment where new products, services, process, and business models which may be deployed on a limited set of users can be tested or can be, let's say, the proof of concept can be made. So these regulatory sandboxes can be made use of for testing out the different systems which are getting developed, let's say for making use of analyzing the traffic data, how the traffic data can be analyzed, how the traffic data can be made use of for, let's say, deciding a use case wherein we want to do a planning for a public transport system from city A to city B. And if we want to know exactly how much population gets moving from city A to city B and back from city B to city A in the morning, in the afternoon, in the evening, in the night, so all that information can be tested through the traffic data, and the necessary planning and appropriate planning could be done for the public transport system. Or if there is, let's say, to need to find out about the migratory patterns of the Indian population, So that also can be made use by analyzing the traffic data, and we can basically draw accurate and a confirmed picture about the migratory populations. So these basically are some of the facilitating provisions which have been included in the Telecommunication Act 2023. There are a very important set of provisions included in the Telecommunication Act 2023, and these are related with the protection of users. A lot of spam gets generated. The users are impacted by the spam messages, etc. So appropriate clauses, appropriate sections have been included in the Telecom Act 2023 to protect them from such unwanted messages. Although a lot of provisions are already existing by way of regulations provided by the Telecom Regulatory Authority of India. Now it has been basically included, and a statutory framework has been provided for all those measures which the TRAI has mandated and which the government can further mandate to protect the users from such type of unsolicited communications or from cyber fraud attempts or any communication impacting the privacy of users and so on. Continuing with the important provision of related with the protection of user, certain duties have also been made available which a user has to fulfill. Like the user has been requested not to furnish any false particular or suppress any material information or try to impersonate another person while establishing his identity. And also it has been indicated that if certain information has been requested under this act, the user is bound to provide that information. So there are a lot of measures which are targeted towards protecting the users, as well as certain duties have been proposed for the users, so that the user is basically able to enjoy the telecommunication services in a free and fair manner without botheration of a cyber fraud or a cyber security incident. Plus other measures have also been indicated. The grievance redressal mechanisms have been defined. Now the user can make use of those grievance redressal mechanisms. User is a very important stakeholder of the Telecom Act, and the grievance redressal mechanisms are there for all the stakeholders, including the user. That was all from my side. If there are any questions, I'll be glad to handle those questions. Thank you.
Thank you, PK Singh, sir. May I request? So there is a question from Mr. Praveen Sharma from PK Singh, sir. Mr. Praveen Sharma, have you raised the hands?
Yes, sir.
Yeah, please.
So, PK Singh, sir, a very good afternoon. 2 or 3 questions to you. One is regarding shutdown of services, which is section 22B. And there the rules are still to be made. And there is already a pronouncement in the Anuradha Bhasin judgment of 2020. So when the rules are made, whether you will be taking care of all the guidelines which are given in Anuradha Bhasin judgment, that is point number 1. Point number 2, when you are talking about monitoring of services, which is under 22A, there the services are also provided by OTTs also. And whether you will be covering the monitoring of the services by OTTs also under this act, particularly because when you talk about the user protection or spam protection, both a fraud protection or a spam protection, for both there are now increasing instances of fraud which is happening on OTTs. I'm not naming any OTT, but lot of frauds you are aware is happening on OTTs, and also the spam is there. So is there any attempt to rein those category of service providers also in the security measures? So this was the question. Thank you so much, sir.
Thank you, sir. A very lengthy question, but I'll basically reduce it to two parts. The first part is related with the telecom service shutdown. You might be aware, sir, that rules are already existing under the appropriate provisions of the Indian Telegraph Act of 1885. There are rules, and the Anuradha Bhasin case, which you have referred, that also has been taken into consideration while framing those rules. In fact, you might be aware that the rules initially, when they were framed, they were basically open-ended. So, taking cognizance of the Anuradha Bhasin case, it was included in the amendment of those rules, and a period and a periodicity of the telecom shutdown was included as part of the amendment to those rules. So those rules are basically going to be the guiding factor with us while we frame the rules under the Indian Telecommunications Act of 2023. That is the first answer to your part one. And the second part is it was a conscious decision to indicate that the OTT service providers are not going to be regulated under the Indian Telecommunications Act 2023. That is the first part. The government is contemplating an act to cover all such type of service providers who are beyond the mandate of the Indian Telecommunications Act. So OTTs are basically going to be covered by the provisions of that act. Our Honorable Minister of Communications has already indicated the intentions very clearly, and we would be abiding by that. But however, when we say that the security provisions which have been included in the Telecommunications Act enables the collection, analysis, and sharing of the traffic data, the analysis of the traffic data, analysis, the results of the analysis, etc. So those things are basically going to be made use of the traffic data which gets generated over the telecommunication network, and the telecommunication network are basically be made use by the OTT service providers. Hence, a lot of telecom traffic data is going to be generated, which might be pertaining to the OTT services being made use by the citizens. And we would be in a position to analyze those specific telecom traffic data and recommend and take appropriate measures and appropriate steps to prevent the users from getting defrauded or users getting cheated by way of any type of telecommunication which is happening in the country. That is all what I want to say for the second part of your query. Thank you. I hope I have answered you satisfactorily.
Thank you, sir.
Colonel Sunil Kakkar, can you please open your mic and ask your question? Colonel Sunil Kakkar.
Yes, sir. Thank you very much, sir, for giving me the chance. Am I audible?
Yes, you are.
Sir, I have two questions. One is that does the Act talk anything about the country of origin for the hardware? Because the pace at which the telecom industry and the technology is going at a faster pace, and we hardly have the capability of in-house production for the advanced and the smaller size equipments. So does it talk anything about the country of origin thing, which has been a very prevailing issue in the recent past due to our immediate border sharing country interventions in our telecom technologies? Second thing is regarding the airtime being used by the broadcasters. Is there any provision that the how much duration has to be compulsorily the content and how much time they can be spending on the advertisements and things like that, sir?
Thank you, Colonel. In fact, you have raised a very important issue. All of us are aware that a lot of equipment gets manufactured in our country, but it is also a fact that a lot of equipment gets imported into a country, which has a bearing on the security of the telecom network and security of the services, and primarily the security of the country also, as the telecom is the bedrock over which the entire infrastructure sectors and most other sectors of economy are relying upon. So if the telecom network is not secure, the telecom services being provided are not secure, then there is an impact on the overall economy of the country and on the nation's security also. So to that effect, when you said the source of origin or country of origin, appropriate provisions have been incorporated in the Telecommunication Act under the Section 21 D, the subsection D of Section 21. It says that the measures as are necessary in the circumstances, the government can issue directions in respect of procurement of telecommunication equipment and telecommunication services only from trusted sources. So who are going to be these trusted sources, etc., has been left to be defined through the rules. And already you might be aware that there is already a mechanism which is available by way of the National Security Directive for telecommunication sector, wherein it has been indicated how the trusted sources are going to be evaluated and assessed, and how the trusted products are going to be evaluated and assessed. And in keeping pace with the NSDTS, the license has already been amended. The unified license has already been amended, which makes it mandatory for the licensees to deploy only the trusted products from the trusted sources. So once a provision has been made available, it only is going to be improved further upon. It is not going to be digressed or taken back. So the appropriate mechanisms have already been included by way of the legal framework, by way of subsection D of Section 21 of Indian Telecommunication Act under Chapter 4, to that effect. And there was the second part, I missed it. Could you please repeat it?
So the second part is are there any regulatory things on the
Okay, for the broadcasting sector?
Broadcasting sector, sir.
Sir, we are basically going to stay away from the broadcasting sector because the OTTs is a contentious term, and it was a conscious decision that the OTTs are not going to be controlled, or OTTs are not going to be regulated by Indian Telecommunication Act, and hence we have kept away from the OTTs. So
there is a separate draft broadcasting services regulation bill 2023 which is also under consultation. So broadcasting related queries can be directed over there, or those inputs can be given in response to that.
Thank you, Praveen Sharma ji. Thank you. Thank you for assisting me in providing the appropriate answer to Colonel sir.
So kind of you, sir. Thank you, sir.
Thank you, PK Sinha sir, for a wonderful presentation and taking up all the questions of our participants. At the end, we are left with few more questions which was there in the chat box, and I request Joint Secretary Technology, Mr. Verma, and Revati Madam and PK Sinha sir to please take these questions. I'll just read out the questions for the benefit of all the participants. So first question is about OTT only, as OTT communication accounts are opened based on telecom mobile number based OTP verification process. Any accountability on such accounts being used for frauds? In addition, virtual numbers are used for opening of OTT accounts. Any measure to prevent such misuse of mobile numbers, including virtual numbers? PK Singh sir, would you like to take this question?
Yes, sir. In fact, a very pertinent question has been raised. I will say there are facilitating provisions available in the Telecommunication Act, but as we had indicated that the OTT services, etc., are going to be regulated through a separate bill and act, which is under consideration. But it doesn't mean that the Telecommunication Act doesn't have the necessary facilitating sections. The traffic data analysis is ultimately going to be made use of for doing a lot of analysis That is the first part. And once we are analyzing the traffic data, as has been rightly indicated that the OTT services run over the telecom network. So a lot of insight is going to be generated by analyzing the traffic data. And that insight, which is going to be made available through the analysis of the traffic data, is going to be used under the provision or with the appropriate authorities, so that the OTT services doesn't become a hotbed for the cyber crimes and cyber frauds. That is the one part of the answer. Another is DOT is already in discussion with the OTT service providers, and OTT service providers, they are basically considered to be basically the perception is that their authentication at the time of service subscription is not so strong. So when the appropriate bill gets drafted, the appropriate mechanisms are going to be incorporated so that the OTT service providers also make use of the telecom identities and the KYC verification mechanism which the Telecommunication Act has mandated and prescribed. So the OTT service providers are basically going to be regulated by a different act, but it will have appropriate mechanisms to take care of the issues and the concerns which are being faced today. And if the Telecom Act is able to play a very important role in that, that role will be continued to be played by the Telecommunication Act in that regard. Thank you.
Next question is from Mr. Vikram Tevitia. If the government, central or state government, wants to take over the telecom network, which entity in the government has the capability and capacity to undertake this work?
I will say, let the situation arise. Mr. Tevatia will find out which entity in Government of India or which entity in the state government has the capability to do that.
Okay. Now the next question is...
The facilitating provisions have been included, and those facilitating provisions would be made use when the situation arises. Thank you, Tevatia ji.
Regarding operators, equipments left over at the site became of insolvency, winding up of operations. Because of insolvency or winding up of operations, some provisions should be available in the Act for removal of equipment from sites by infrastructure providers or taken over by DOT term cell.
Is it a question
not to you, not to you, sir? It could be from JS admin, JST.
I will request one thing, because I have seen some good suggestions in the chat box. Okay. So NTIPRIT may please compile it and give it to us so that when we the rules, we take care of the
do that.
Yeah. Okay. Thank you.
So you want to say that this one is like a suggestion, and we will send it to us for your consideration.
It is a kind. I think it should be taken care of while framing the rule, because it appears to be a kind of some technical issue. So we will see that.
PK Singh said another question is from from Mr. Sachin. Would there be any changes in LI SOP of 2014, or does it prevail as it is?
The SOP which has been prepared has taken into consideration the current law, and I don't think there is a need of changing the SOP, or there is a requirement, or there is a need of changing the rules which have been framed for facilitating the lawful interception. But however, if certain suggestions are there, we can consider those suggestions, and if a need is felt, we'll incorporate it. But as of now, the existing lawful interception mechanisms, existing lawful interception procedures, and the rules are taking into consideration the directions provided by the Supreme Court, and I don't feel that there is a need of tampering or tweaking those lawful interception provisions. Thank you.
So we can request our participants, if they have any specific suggestions, if they can please mail it to NTIPRIT on the given address. Siddharth will once again type his mail ID into this one, and whatever suggestions are received, we will certainly compile it and send it to DOT for their consideration while framing the rules. Now the next question is from Revati ma'am. Many departments have a spectrum assigned and their usage has been very low, but they have not been asked to surrender their assignment. How will this be addressed while there is a provision in the Act, but it is not implemented? How will the need for periodic spectrum users audit be done? This is a question from, again, Mr. Vikram Tewatia.
Actually, yeah, it's a ongoing process, spectrum audit by the self-assessment audit, and we have done through CAG. We have requested CAG. So far, CAG used to come to DOT and do the audit here. We told CAG went to all the spectrum users, major users like MIB, DOS, Defense, and the CAG has come out with the performance spectrum management report.